Thank you, everybody. Have a seat. Hello. Commonwealth versus Thomas O'Donnell.
Good morning, Judge.
Good morning. You Thomas O'Donnell?
Yes, sir.
Good morning. This is 22 CR 00103. Mr. O'Donnell, you born in 1961.
Yes.
Last four digits, social security number 6773, correct?
That's correct.
Are there motions? The motions on, go ahead and state your motion to exclude.
Yes, Judge. The first motion is just motion to exclude
If you
404B.
come over behind, the music is kind of knocking it out a little bit. You just need to go over directly behind the microphone and be a little louder, please.
That's a motion to exclude unnoticed 404B evidence, and we're just asking the court to set a deadline of 45 days prior to trial for the Commonwealth to notice any 404B evidence.
You
they
don't have
intend
any
to-
problem with that, do you?
I do not. I don't even know of any 404B evidence. It'd have to be really compelling before I try to introduce it now.
Okay, well, we'll go ahead and submit an order on that.
Thank you.
Motion to permit.
Yes, Judge, we have filed a motion to permit the defense to call a handful of witnesses via remote testimony. The primary basis being that the face-to-face,
What kind of witness you talking about?
these would be witnesses material to both the merits phase, the interim aggravator phase, and the sentencing phase. And like I said, we don't plan on calling any more than
Tell me
6.
who's the merit phase witnesses you're talking about.
These are 3 witnesses that would be from California.
Well, I don't know, are they expert witnesses? or-
No, Judge, all of these are lay witnesses, including
They
some
don't
of
want, I'm having trouble with this bail here. I appreciate the Christian Church providing that, but let's listen to it for a second because you're breaking out of it. Okay. Oh, no, not okay. Okay, you're talking about merit witnesses.
Yes, Judge, there are some witnesses that will have testimony material to the first phase, and then we have some witnesses, including family members of
If
Mr.
there is a second.
True, yes. If there is a second phase, we have some family members of Mr. O'Donnell that we would want to call over Zoom,
So
including,
these aren't expert witnesses.
right, these are just lay witnesses, and I don't believe,
How do you feel about that, Mr. Stock?
I had different feelings, Your Honor. At first, when I saw the motion, I wasn't in agreement at all. But since then, I filed a motion to authenticate certain records so I can introduce those without calling witnesses. And I think defense counsel and I have reached an agreement where I'm not going to object to their Zoom witnesses. And they're not going to object to me filing these records under KRE 902 when they're properly authenticated. And I told them there's 4 sets of phone records in this, but I went over with them just so we'll have it on the record. I wrote a letter back July of 2025 asking for stipulations of certain things. So there'll also be records from Home 2 Suites, Fort Smith, Arkansas, Quality Inn in Cookeville, Red Rock Casino in Nevada, Maristar Hotel in Colorado, the divorce petition, which they agreed to, the flight manifest from Southwest Airlines, and the chase records.
Okay, what?
So that'll help speed the trial up
Yeah,
greatly.
well, I appreciate that. So we want to know that we're doing this with specificity.
Yes,
Let's have an agreed order that sets out the stipulations. Does that make sense?
Yes, Judge.
And anything that's not in that order is not stipulated to.
that's correct.
Okay? Okay, thank you.
Thank you, Judge.
Motion to secure. Is that you? Ms. Costello,
I'm just,
you doing the potted plant bit today?
I am, Your Honor.
Judge, there should be an order tendered on that 404B motion. I just wanted to make sure that you've got that. Okay, great. And as far as the March date, I know that it's not on the normal docket day and none of us are available on that day. I was going to ask if we could set a final pretrial in March on a special date.
I don't give them. Yeah. Well, we're on March, aren't we? Pretty much. Uh, But what about doing the pretrial in April? We don't start until the fourth week, right? Is that correct?
Yes, Judge.
So April seems to be more open.
And is there a regular docket the first or second week of April, Judge?
Clinton County on the night.
Yeah, we could do it in Clinton County. Let's just do it in Clinton County on the night.
That'd be fine. Thank you, Judge.
Okay, now, is there anything else?
Your Honor, I think you mentioned once before, possibly maybe starting jury selection on the 24th. You're not gonna do that? Okay.
I had hoped to do that, but I've got a conflict.
Well, I just want to know because that way I can tell my witnesses what day to be here.
So we're not gonna be able to, you counsel want to come up here and you can bring Mr. O'Donnell with you.
Yes, Judge.
Let's do the bench conference thing just for a second. On this Commonwealth versus Terry Aaron. This Commonwealth versus Terry Aaron, 25 CR 00081. You are Terry Aaron.
Yes, sir.
You were born in 1987.
Yes,
The last four digits, social security number 6691.
Yes.
Okay, you're here for the purpose of sentencing. Have you had an opportunity to review the pre-sentence investigation report with your attorney?
Yes.
Counselor, is it substantially correct?
It is, Your Honor.
Is there any reason this gentleman should not be sentenced?
No, Judge.
Upon a plea of guilty, possession of controlled substance, first degree meth, the defendant shall receive a sentence of 2 years probated, however. In 3 years, probation would be supervised. Defendant shall be assessed and following recommendation of social service clinician. What's the court cost this case?
$190.
You need some time to pay that?
Yes, sir.
Okay, I will make your first payment of $30, 30 days from today, and $30 every month until it's paid. Okay.
Right.
Hey, thank you very much. Basic parole officer right there. Ronald Burton. Morning. You are Ronald Burton.
I am.
You're here on 26 CR 0005. Mr. Burton was born in 1987.
I was.
Last four digits, social security number 3843. You're here today for the purpose of arraignment. The grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance in the first degree and possession of drug paraphernalia. Counselor, you acknowledge the identity of your client. You see the indictment, waive formal reading and arraignment.
Yes, Your
Is there
Honor.
going to be a plea here?
Judge, we also have a plea for the court to consider.
There is going to be a plea here. Okay. Is it felony plea? Diversion, okay. Get that out here. A motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
I'm currently.
Is this plea freely and voluntarily given? Is plea freely and voluntarily given?
Yeah.
Okay,
Yes, sir.
I mean, if it isn't, we can,
No, I'm in treatment right now.
well, I just asked if it was free and voluntarily given, the plea.
I don't understand. I've never been in no trouble. I
In
don't.
other words, is anybody forcing you to do this?
No.
Okay, are you the same person we just identified in the indictment, 26 CR 005?
Yes, sir.
Is your judgment impaired today in any way? You know what's going on? Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Okay, have you reviewed the evidence the Commonwealth has against you and you believe you're fully informed about your case?
Yes, sir.
Okay. You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. I'm going to go over those rights, and at the end, I'm going to ask you if you understand them, okay? You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury. You have a right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you. You have a right to produce evidence, a right to call witnesses in your favor and appeal this matter to higher court if you lose. And you have the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that entering a guilty plea that you give up those rights. Do you understand that? But now I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. After hearing the recommendation, if I decide not to accept it and decide to impose a harsher sentence, you have a right to withdraw your plea, proceed to trial. And I'm going to ask you a few qualifying questions. Okay, have you been previously diverted in the last 5 years? Have you had a pretrial diversion in the last 5 years?
I think so.
Have you ever had a felony charge?
Oh, no, sir.
Have you had any felonies in the last 10 years?
No, sir.
Are you currently on probation?
No, sir.
You understand if you fully complete the diversion program, the charges will be dismissed, pretrial diverted, you get your record expunged.
Yes, sir.
You also understand if you do not successfully complete the diversion program, you brought back in front of the court, schedule a sentencing hearing. You would be a convicted felon, which could be used against you in future. You understand that?
Yes, sir.
Mr. Gordon Anderson, could you give the recommendation of the Commonwealth?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 2 years, pretrial diverted for 3 years. Diversion is to be supervised. The defendant shall be assessed and follow any recommendations of the social service clinician. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service per week until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that what you agreed to?
Yes, sir.
Are you pleading guilty because you did commit the act charged in the indictment as amended?
Yes, sir.
Okay. You're doing so of your own free will. Knowing your constitutional rights explains it's still your desire to give up those rights, enter a plea of guilty and allow the court to fix your punishment is permitted by law, subject to the limitations I gave you. Is that your signature on the document?
It is.
I'll accept the agreement, sign the diversion order. What are the court costs? $190. You need some time to pay that?
Judges, there are already plea documents in the file, or do I don't know if I have the originals or not. Honestly. Okay.
Has it been signed? Okay, so you just have a copy of it. Yeah. Okay, I'll let you pay $30 a month. You sit back on your feet a little bit, okay?
That'll be fine.
In 30 days from today, make the first payment, and $30 every month you make that payment.
I got it.
Probation pro officer right back there. Good luck to you. Ethan Combs. Commonwealth versus Ethan Combs. Does anyone know about the presence of Ethan Combs? To be arraigned and enter a plea today. Does anybody know?
He was supposed to be here and enter a plea on the right, if he's not, I guess. We'll proceed.
Who represents Ethan Combs?
Judge, we had him in district court. I've got signed paperwork. It's probably a copy, but I've got signed paperwork in the file.
Okay, well, issue a bench warrant without bond, Mr. Combs. To appear on March 24th. Jerry Compton. Jerry Compton. Commonwealth versus Jerry Compton, 26 CR 006. You're here for arraignment. Are you Jerry Compton? Good morning. Were you born in 1973? Last four digits, social security number 4287, represented by Mr. Cross. Here, you're here for the purpose of arraignment. You have a right to remain silent at any time that you wish to discuss or don't understand, step away and ask Mr. Cross, okay? The grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance, first degree, methamphetamine, possession of a drug paraphernalia, careless driving, and failure to use a seatbelt. You understand what those charges are. Mr. Cross, do you acknowledge the identity of your client, received the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, I'm going to sign a reciprocal discovery order. Requiring the Commonwealth to provide you the information to help prepare for the defense. What is the negotiation day for next month?
March 13th at 9 a.m.
March 13th at 9 a.m.
Brother, I hope I'll be at the basketball tournament. It depends on how they play.
But we're gonna
if
miss
not, I'll
you.
arrange
And March
to
the
kick off
March the
the
24th. March 24th.
Your Honor, I note that I've got Metcalf at 9 that morning too, so I will think I can probably take care of Metcalf and then get here later. That's all right.
We'll be here for a while.
That's what I figured. I just got one case over there, so.
Okay. No reason that this gentleman can't be continued on the same bond, so.
Thank you, Ralph. So I'll have this morning, y'all.
Have a blessed day.
Thank you.
Mary Crawford. Mary Crawford. Commonwealth versus Mary Crawford, 26 CR 007. Are you Mary Crawford?
Yes.
You born in 1972?
Yes.
Last four digits, social security number 7307. Represent the Office of Public Advocacy in District Court. I'll continue. Do what?
Yeah.
Okay, I'll continue the appointment. We're here for arraignment. You have a right to decide. If you have any questions, you step away from the podium and ask your turn. The grand jury of Cumberland County who has returned an indictment charging you possession of controlled substance, first degree methamphetamine, possession of controlled substance in third degree, possession of drug paraphernalia, possession of controlled substance not in the original container, operating a motor vehicle under the influence, improper equipment, bad muffler, careless drive. The dreaded muffler charge.
And that's a top priority.
I'm signing a reciprocal discovery order. It requires the Commonwealth to provide you with information on how you carry your defense. You used to be here on March 13th at 9 a.m. for a negotiation day with your attorney, and March the 24th for your next court date. Both of those are conditions of your bond. See no reason why you should not be continue on the same bond. You're free to go.
Judge, she is on a leg monitor. I assume that was us given down district court. She's been on that for about a month and a half
I
now.
don't know anything about her, don't know anything about the case. You can talk to Commonwealth about it.
It's become an expense issue for
Well,
her.
you can
She can't
talk to
afford.
Commonwealth about that. Unless you want a hearing, because I don't know anything about why it was put on there in the first place. It might be something I'm not aware of or you're not aware of, you know?
Well, I'm certainly not aware of it because I was on
I
district
think
court.
we'll get with Alan and investigate, but I'm kind of unsure why she's got one.
Yeah, it's real expensive.
Okay, well, we'll take that in consideration, and I won't make you come back again. If the Commonwealth agrees, I'll agree, okay?
Yeah.
Okay, thank you.
Hopefully by the time we meet on the 13th.
Dixon Escalona. The active warrant,
Put it in CIC.
NCIC, please. Beth Garman. Where's Beth Garman?
She's here, John.
Yes.
This is a felony plea.
Okay. Now I want to put on the record that Miss Garman's mother came over to my house to see me, but she was very kind, and she didn't talk about the case. She just talked about her health concerns of her daughter. But I wanted both sides to be aware of that. I've known her mother and respect her mother for a long time, so it had no effect on the case. A motion is tendered, says you wish to enter guilty plea. Is that correct? Okay. Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Are you the same person that was named in 25 CR 0064? Yes. Okay. Is your judgment impaired today? You know what's going on here? Okay. Have you discussed these charges with your attorney? Are you satisfied with his advice?
Yes.
Have you reviewed the evidence that the Commonwealth has against you? You believe you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm going to go over the rights. If you have a question, you can step away and talk to Mr. Poindexter about it, okay? You have a right not to testify against yourself. No one make you say anything. You have a right to speedy trial, but jury right to be represented by counsel at your jury trial. That confront possibly and all witnesses called to testify against you, right to be said, this right to have a decision in favor. The right to appeal this matter to a higher court if you lose, and the right to private conduct for the reason that which you go to charge. You understand that? But entering a guilty plea today, you waive those rights. You understand that? Okay, now I may consider the commonwealth's recommendation by me upon the range of sentence provided below. I don't have to accept the recommendation prior to accepting any recommendation. I will waive the precinct's investigation report number probation. In the event that I do not accept the commonwealth's recommendation and decide to impose a harsher sentence, you'll have a right to withdraw your plea and have a jury trial. You understand that? What's the commonwealth's recommendation, Mr. Johnson?
Your Honor, Ms. Garner will plead guilty operating a motor vehicle under the influence of alcohol or other substance, fourth offense. She'll receive a sentence of 5 years, serve 120 days, balance probated for 5 years. Probations be supervised. She'll also be agreed to be assessed and follow all recommendations of the Social Service Commission, pay court costs at discretion of the court. All evidence in this case will be destroyed, and the Commonwealth's waiving any work requirements in this case.
Is that what you agreed to? No. Are you entering this plea because you did commit the acts charged in the indictment as amended? You're doing so of your own free will. And the constitutional rights of guarantees is still your desire to give up those and let the court fix your punishment. And do you understand by entering a plea, any future convictions of felonies could enhance the range penalty under persistent felony offender law? You understand that? Is that your signature on the motion?
Yes.
Okay, I'll accept the plea and order precinct's investigation report, schedule sentencing for March the 24th. Now, I do have a notation here that surety you requested him come off the bond. What's that about?
Here, the surety's here.
Who is the surety?
Her sister, Cheryl.
You want to come around?
All right, just to confirm, March 24th is Tuesday?
I don't know.
Yes.
Yes.
Okay. All right.
Yes, you want to come off the bond, do you?
I do, if it costs her to go to jail, I don't, but I just feel,
Well, it will cost her to go to jail unless she can get somebody else on the bond.
I can stay on it till she can get somebody else.
Well, it's up to you how long you stay on it, you know.
Just
I
feel like-
can't, you know, if she comes off that bond, she'll be put in jail until somebody else can make the bond. The bond's a low bond. The only thing left to do now is the sentencing. No, so she was going,
Was you planning on putting her in custody today anyway, like normal, or are you gonna let her stay out till sentencing?
well, it hadn't been addressed,
Okay,
you know.
I thought that might make that issue moot. I didn't know.
Well, it might, but here's the deal. I don't know whether the jail is capable of taking care of that. So I will leave her out if you'll stay on the bond. Normally, what Mr. Stockton brings up, normally when somebody enters the plea,
She's got to go by the rules, I've been told her.
yeah. So if she violates it, you know, the only way you'd be responsible for anything is she absconds if she leaves.
Okay.
Okay, any of these other rules we'll take care of.
I'll stay on,
Okay.
if she
Okay.
violates the law.
I'm gonna allow you to stay out on this bond because of the health considerations that previously been addressed here in this court. Do not violate the bond. You can be subject to random searches. You're gonna waive your Fourth Amendment rights. They can search wherever you're living, and you also need to make sure that we know where you're living. Okay? Thank you very much. Kristen Garner. Kristen Garner. Was she given notice to be here?
Yeah, he was notified by
It's a
mail.
he, so
I think that he reported to Mr. Garner.
DPA represent Mr. Garner.
I believe we did, Judge. I didn't get the motion until yesterday myself. I reached out about circumstances of it.
It's not the most heinous motion, but he's young and he's not working. He won't do community service, so he won't appear in court. So there's an issue.
He
going
should
on.
have bench warrant. He wants to get the bench warrant, counsel, you'll have an opportunity to talk to him, and if y'all can work out things, get him in line, I'll consider putting him on the docket next time. Jason Graham for arraignment. Are you Jason Graham?
Yes, sir.
Good morning. You're here on 26 CR 004. Office of Public Advocacy represented you in district court. I'm gonna continue that appointment. You were born in 1994.
Yes, sir.
Last four digits, social security number 3322.
Yes, sir.
You're here for the purpose of arraignment. You have the right to remain silent. The grand jury of Cumberland County is charged you with fleeing or evading police in the first degree. Operating over vehicle under influence. Failure to signal. Reckless driving. Possession of an open alcoholic beverage container. Speeding. Failure to use your seatbelt. You understand what those charges are?
Yes, sir.
Counselor, you acknowledge the identity of your client, received the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motion.
Yes, Your Honor.
Okay, I'm signing a reciprocal discovery order, sir, that require the Commonwealth to give your attorney the information that you prepare for your defense. You be here on March 13th at 9 a.m. for a negotiation, and March 24th for your next pretrial. Both of those are conditions of your bond.
His treatment was on Cumberland.
Has he been processed? Is that what you're saying? He hadn't been processed? The sheriff department can process him?
We have a vote.
Yeah. Evidently, he had never been served. Is that, does the record indicate somebody got the file, look at it, see if he's been served?
Unless he got service.
He's got a pretrial services supervised release order that was signed this morning, apparently. I don't know.
That was just for NCR.
That was just,
Okay, well, he just needs to stay here. Will you send somebody over to process him? I'm not gonna take you into custody right now, but you stay here in the courtroom and watch Mr. Deputy Abernathy. If he signals to you, they'll take you and process you, do the photo and that sort of thing.
Judge, what is the bond currently? If there,
What's the bond?
$25,000.
Yeah, can you make that?
His father was supposed to make it today.
25 surety?
Yeah.
My dad is here.
Yeah, well, you go downstairs in the clerk's office. Has he made the bond? Have you made the bond yet?
They already had it on lane.
I can't hear you. I'm sorry.
Please, I bring a skateboard trying to have a home here.
Okay, well, so you have property here in Cumberland County.
Yeah.
Just go down to the clerk's office and start the process, making the bond. And by the time they come here to process him, he can leave with you if you make the bond, okay? Clerk's office is on the first floor. You just go down there by yourself and make the bond.
He's in a voluntary.
You what?
He's in a voluntary rehabilitation.
Well, we're gonna get him out of here once you make the bond, okay? You make the bond, he gets his photos, and he can be on his way rejoicing. Okay? Thank you. You show this gentleman where the clerk's office is. The bailiff will show you where the clerk's office is. March 13th and March 24th. The defendant will remain in the courtroom and until he makes a bond, and father can go downstairs. Michael Harris, Commonwealth versus Michael Harris, 21 CR 0021. It was a motion to forfeit. Was there a gun or what was it?
No, it was a car, Your Honor, a 2010 Chevy HHR. He's the one that had about 3 or 4 ounces of meth. He got a long prison sentence.
He hadn't responded to the motion. Got no
Okay.
problem. Go ahead and forfeit.
We will,
Christopher Hill, arraignment. Are you Christopher Hill?
Yeah.
Good morning. You're on 25 CR 0071. Mr. Hill, were you born in 1990? Last 4 digits, social security number 4432. You're here for the purpose of arraignment. You're represented by Mr. Parrish. Is that correct?
Judge, I'm standing in for the purposes of arraignment for Mr. Rhett Ramsey. He will be continuing his representation.
Okay, Rhett Ramsey will be the attorney of record. The grand jury of Cumberland County has returned an indictment charging you with fleeing or evading police in the first degree, wanton endangerment in the second degree, operating motor vehicle under the influence, expired plates, careless driving, and reckless driving. You understand those charges? Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Judge.
Okay, I'm signing a reciprocal discovery order. Are you gonna take the discovery and get it to Mr. Ramsey?
Absolutely, Judge.
The negotiation day is March the 13th and the next court day is March the 24th. Be both days here at 9 a.m. as condition of your bond.
I just want to put on the record, he already has discovery through DocuShare, so we provided it to Mr. Hampson.
Okay, that'll be fine.
I'll also email to you.
Okay, thank you. Thang Lu. Commonwealth versus Thang Lu.
That's another notice of intent to forfeit. It's a 2013 Chevy Cruze. We sent notice to Mr. Poindexter. He was his attorney of record.
Oh, which case?
Thang Lu.
Oh, I haven't heard that name in a long time.
Forwarded in a car.
I apologize, Your Honor. I've not had any contact with Mr. Lee.
You didn't have any kind of assignment of the car or anything?
No, sir.
Okay, but I guess you lack interest there.
No, sir.
So we'll sign a forfeiture order.
Okay.
Kingsley Maggard. Commonwealth versus Kingsley Maggard, 25 CR 0083. Are you Kingsley Maggard?
Yes, sir.
You born in 1997?
Yes, sir.
Last four digits, social security number 1987.
Yes, sir.
You're here for a pretrial conference.
Yes, sir.
What we got going on here?
Your Honor, she has a co-defendant. I think he's supposed to have counsel today. Can we just set her for the next negotiation and pretrial? And I won't require her to be here. She'll just attend by telephone since she works.
What's she charging?
It's possession case, but it's heroin and fentanyl in the possession.
Where do you live?
Virginia.
Oh, okay, I remember.
You remember she was
Yeah.
passing through.
Yeah. I have no problem with her participating.
I think
Online.
So I just have to do just one.
You gotta make sure.
Okay.
What do you want to do? You want her there for the negotiation day by Zoom and here by Zoom?
Well, I think she'll either need to be back there on the 24th, either to enter a plea or set a trial date, so.
So the 13th is what you want the Zoom.
Yes.
So negotiation day, counselor, on the 13th at 9 a.m. Central Time. You're on God's time here. You're not on the East Coast time.
I know. I feel like it's coming.
Excuse me a second. Excuse me. Hello? Okay, you need to text some of them on the bench. Thank you, yeah, a pre-trial. So she's gonna be on Zoom on the 13th at 9 a.m. Central Time. And then on the 24th, she'll either be here to enter a plea or schedule a trial. If she decides not to enter a plea, can we set the trial by Zoom?
Yeah, that board.
Mr. Stockton?
Yes.
Okay, so if you decide not to enter a plea on the 24th, you can do a Zoom appearance. Okay, is that okay with you, Counselor?
Yes, Judge, and I think if she could appear for the settlement conference on the 13th, we possibly could do the paperwork. We have,
Well,
and she can appear by,
it's up to you. I'm allowing her to do Zoom or she could be here in person.
Whichever way you prefer to do it.
You know, and as far as that concerned, even if she was here on Zoom on the 13th, you know, she could email, you could send her the document somewhere. She could sign it. She could, you know, I don't know whether she has this ability to sign things
I
online,
can.
those signature things.
Yeah, I
that she
can do
has.
that.
You work that out.
that.
She can come if she wants to. She wants to enter a plea, we'll accept the other, okay?
Okay.
And then once she enters the plea, she'll need to come here for sentencing in
Okay.
some junction.
Well, I'm hoping that I'm hoping it may be a diversion situation.
Hope springs eternal.
That's right.
Okay, thank you.
Thank you.
Yeah. Brian Muse. Brian Muse. So you want to know where Brian Muse is? Motion to forfeit, he has no objection.
He just would like to thank the vehicle.
He was what?
He just wants to get his things out of the vehicle. We're gonna call sheriff's office.
That'll be fine. Sign the order and you get any personal property that's not an illegal substance.
Yeah, I'll put in there in 15 days.
Okay.
No.
Okay, April Nethery.
She has conflict, and so she should be conflict, but
Commonwealth versus April Nethery, 25 CR 0072 and 25 CR 0073. Good morning. Were you born in 1981?
yes, sir.
Last four digits, social security number 5139.
Yes, sir.
Do we have counsel on?
Your Honor, this is Greta Atherton. I represent Ms. Nethery. I apologize that I got stuck in McCreary County. I'm actually still here.
Well, there are worse
There
places.
is an issue. Yes, there is a situation in this case. I wasn't aware of the procedure that the Commonwealth used in order to obtain buy tapes. So I need to get with the Commonwealth about getting that in Ms. Nethery's cases in order to proceed further. So I was going to ask the court if possibly we could do another one of the, I think you all, maybe they're called settlement conferences there, along with another pretrial conference.
You had trouble getting discovery? Is that what you said?
Well, this involves some confidential informants and videos, so she may need additional discovery and we may have to sign an order so if we can disclose all that information. So I don't mind having we need another negotiation day anyway and pretrial conference.
Negotiation day on March 13th. Negotiation day, March.
That's good for me, Your Honor.
At 9 AM and the next pretrial is on the 24th. If you don't get everything you need on March 13th, then you can file any motions or whatever on the 24th. Ms. Nethery, you're released under the same bond. You need to be here. Counselor, do you have Ms. Nethery's contact information or does she need to contact you?
No, I have it, Your Honor. We've been in contact with one another.
Okay, thank you very much.
Thank you.
You may be excused. Yeah. Ricky Purdue, Commonwealth versus Ricky Purdue. Are you Ricky Purdue?
Yes, sir.
Good morning. This is 25 CR 0067. Mr. Purdue, were you born in 1981?
Yes, sir.
Last four digits, social security number 1284.
Yes, sir.
Okay, we're here on a pretrial conference. What do we have?
Well, I'm ready to go on this case as far as depending on movement. Mr. Shepherd wants one more pretrial conference because Mr. Dew has a doctor's appointment or something. He can go there.
He's seeing a cardiologist tomorrow and obviously there's potential jail time involved with a plea agreement. So we need to know where he's at with cardiologist before we proceed.
On the negotiation day on the 13th?
Be fine.
Negotiation day on the 13th, have your client to bring any medical information he has with him on that date, okay? The next pretrial is the 24th. So with the 13th and 24th here at 9 AM, both of them conditions your bond, okay?
Thank you.
Jamie Scott. Commonwealth versus Jamie Scott. Excuse me. Good morning. Are you Jamie Scott?
Yes, sir.
You born in 1984?
85.
5, please let the record be corrected on the docket sheet. Last four digits, social security number 9033.
Yes, sir.
You're on a probation revocation. What do we have, Mr. Stockton?
Your Honor, Ms. Scott is on a drug paraphernalia 12-month sentence, unsupervised misdemeanor. However, she picked up a DUI on February the 16th of 2026. So That case has not been completed down there, but I wanted to preserve my motion and also place her on supervision during this time.
So the only change you wish to make is put her on supervision.
At this point in
How
time,
much time does she have left on probation here?
Have to look and see. So.
2 years, but it's got normally look.
It'd be 2 years from the time the food center, but I need to call one sooner. I have to go to my.
Let's check on that.
Yeah.
Check, see what date the plea was in. July 31st, 25. Hadn't been a year yet.
and I'd ask you to be placed on supervision, continue this next month, and I'll get with the officers and see if I want to go ahead and pursue the revocation or take other measures.
Okay. Schedule her to reappear on the 24th of this month, condition of your release. You're not under bond, but I'm giving you an order to be here today. If you aren't here, you'll be in violation of the order, okay? You need to meet with probation and parole officer. I'm gonna put you on supervision at intervening time. William Spears. Commonwealth versus William Spears.
That is a notice motion for 2005 Pontiac Grand Am.
No objection, I'll sign the order. Cody Stinson.
As far as I know, Your Honor, he's still in my Louisville hospital. I've not heard anything else unless the clerk's been informed otherwise.
She does that paperwork. She's one of the doctors. She probably has to-
So he is still there.
I'll just continue that to the next rule day. We'll review it then. Jason Thrasher, motion to forfeit.
He has actually retrieved his vehicle and settled up with the sheriff, so I'm withdrawing that motion.
On the motion. Barry Wilson. Barry Wilson, Commonwealth versus Barry Wilson, 24 CR 0037. Are you Barry Wilson?
Yes, sir.
Good morning. Are you born in 1941?
In 1934.
74?
Yes.
Well, you've already gained 30 years.
I know
So
it.
I couldn't do anything to help you. Last four digits, social security number 8456. You're represented by
The last
DPA.
four digits of a social security number are called the serial number.
I got a letter from Jesse Stockton's office saying I had to be here today.
Yes, Your Honor. He has also 12 months probation on a misdemeanor possession of drug paraphernalia. He's unsupervised. He picked up a new charge, possession of controlled substance, first degree on February the 10th, 26. I don't, is that going to grand jury today? Barry Wilson. I don't think it is. I would like for him to be placed on supervision. And also then we'll deal with the new felony and try to wrap it all up at once, maybe.
Well, if they're not gonna return the indictment today.
There won't be one today. We could possibly do an information, or I can have it ready by next month.
Yeah, let's see if you can do the information to get it back in front of us. Counselor.
If we could set it the 13th for negotiation then, and then 24th.
They said court date.
Wait. Step back and talk to your attorney.
You've got to have district court dates that you need to go to,
Right.
but then we're going to.
Or is it court?
Court dates that you can come to here. Okay.
Is that a Clinton County charge?
I think it'd be.
I believe it is in Lincoln County, so it could probably go to grand jury on March the 5th. I think it's the next motion day, next Thursday.
Okay.
Yeah.
Well, let's just schedule him for a negotiation day then. On the 13th and on the 24th, have a pretrial.
I'll talk to Mr. Sheff if he wants to sign the information, that might save him.
Yeah, and then we could transfer the case over here for the purpose of convenience if there's gonna be a plea. Okay? Thank you. Your other conditions, your same bond. So you live at the foot of the cross. You understand what I mean? Don't be into anything.
Yeah, and I want him to be supervised with Mr. Garner also, if that's all right.
I think that one, if it's in Clinton County, I think
The probation is here. Who's supervising him now?
He's unsupervised at the current time, Your Honor.
So he's a Cumberland County resident. So if he was supervised, it would be your supervision, okay?
Yes, sir.
You meet with Kenneth Woods. Commonwealth versus Kenneth Woods, 20 CR 0040. Are you Kenneth Woods?
Yes.
Good morning. You're represented by Mr. Kennedy.
Yes,
Were you born in 1960?
Yes,
Last four digits is social security number 8992.
yes.
Have you had an opportunity to review the precinct's investigation report by probation and parole?
Judge, I have not seen that yet. You got a second, I'm sorry.
You have a copy of it?
I did not receive a copy of it. For today.
And that too, you have mine. Take him back in the back room back there. Anytime you have a sentencing here, if you don't have the precinct's investigation report, there's no reason for you to come. So if you don't have it, inquire, okay?
Okay.
Take him back in the back room back there. Thank you.
Will do. Thank you.
The next thing is scheduled at 10 o'clock. For Little Sandy. Little Sandy, are you on there, Little Sandy Corrections?
Yeah, we're here.
Okay, well, we'll go ahead and do that if y'all are ready.
We're ready.
Thank you so much. This is a Cumberland Circuit Court action number 25 CR 0016, Commonwealth of Kentucky versus Scott Barlow. Are you Scott Barlow?
Yes, Your Honor.
Good morning.
Good morning.
Born in 1971.
Yes, sir.
The last four digits of her social security number 1542 is a motion for shock probation. You want to
Yes, Your
present it?
Judge, it's my understanding, this is originally filed by my predecessor, but I think there's a good deal of restitution in play here. The Commonwealth was asking for substantial, I think probably around the $10,000 range.
Give me refresh me on the case.
Your Honor, this is a case where Mr. Barlow stole a utility trailer from a contractor locally here in Cumberland County. He was traced almost immediately to Indiana. Utility trailer was recovered. However, all the personal property and tools was gone by the time Indiana authorities responded. So it had to have been an organized plot to take the trailer up there and remove everything. And it was anywhere between $30,000 and $40,000. We negotiated a 10-year sentence, and I've been in contact with the victims. They don't want him out on a payment plan. They'd rather him serve his time. If he could pay a substantial amount, they'd be willing to do shock. But I really don't blame them in this case. Mr. Barlow's got a year and 7 days in. It's a 10-year sentence. He's up for parole February of 27. That's probably when the parole board will grant it. And also to complicate this matter, even if we let him out on shock, Indiana's got a detainer on him. So there's no guarantee, even if he got shocked, he could pay anything. Restitution. So Commonwealth's opposed.
You have anything to say, Counselor?
No, Judge, I was gonna ask the court to give him a payment plan, which obviously the Commonwealth is opposed to. I've talked to his mom, and I don't think there's a large amount of money.
Well, I guess, how
They
much
paid.
was the amount total before he negotiated down?
It was about $40,000. I think we
And
put
what are they
30,000.
willing to take?
Well, the last time I had contact with them, they wanted at least $10,000 to $15,000 down, and then before he even agreed to a payment plan. And I just don't even know, depending on what Indiana does with him, whether he'd be even to be able to make a payment plan, if he's gonna be in custody up there, once this sentence is served.
I would agree to do a $10,000 payment and put him on a payment plan and extend his probation till the restitution is made in full.
Or is the court saying the $10,000 payment has to be made before he's placed on probation?
Yes, and then the rest of it would be a payment plan, and he would agree to extend his probation until restitution is paid in full. That gives him a chance to get out and get to work for $10,000 down. That gives them some certainty that these people will get something out of it, because if Indiana prosecutes him, he might be in jail. I don't know what he's being prosecuted for up there, but You know, if that happens, he gets incarcerated, you can come back in and we can delay his payment plan, not to revoke account. You see what I'm saying?
Yes, sir. I'm Mr. Barlow. You and I need to get together about this $10,000 payment if that's gonna be a possibility.
Okay, I'll have to get my family and have them get with you on that, if
Okay,
it's okay.
okay.
I couldn't hear what he
He said he
said.
was gonna get his family to contact you to see if they could make arrangements. He wasn't sure yet.
Okay.
Is there anything else, or can little Sandy be excused, Mr. Barlow be excused?
Yes, sir.
Little Sandy, thank you for your cooperation. You guys may be excused.
You're welcome.
Thanks, Your Honor.
Yeah. Pulaski County Detention Center. Are you on there, Pulaski County Detention Center?
Yeah.
Yeah, there you are. Commonwealth Kentucky University, James Creech. Is that how you say your name, Mr. Creech?
3D.
Creedy, okay. This is 22 CR 0042. Mr. Creedy, were you born in 1988?
Yes,
Last
sir.
four digits, social security number 6376.
Yes, Your Honor.
This is a pretrial diversion revocation. What does the Commonwealth have to say?
Your Honor, the revocation is based on the fact he was at Spark. He left them and absconded September the 3rd of 2025. Well, I did too, but I don't see anything on there from drug court. Yeah, and I guess that's the confusion, reason I don't have any. Yeah, and I've been informed by Mr. Sheffitt that he was in drug court in Pulaski County. I just don't have any documentation. I assume he was terminated up there.
He was. And my understanding is that it was originally a Cumberland County case. And then I don't know if we accepted him here and he got transferred or how that works, but
Used to, you would transfer the whole file, but I think they've changed that. It doesn't now. the
Mr.
file's-
Garner seems to know something about it.
Transferred, everything transferred back.
Oh, okay, according to Mr. Garner.
Once
it
they
was-
discharged.
Yeah, once they discharged it, they gave it back to the South
So you're gonna
Carolina.
stipulate to the pretrial diversion revocation?
Judge, our intention was to stipulate to the violation.
Okay, we'll stipulate to the violation, order pre-sentence investigation report to be done by probation and parole. Have the sentencing on March the 24th. Okay, thank you, Pulaski County. You are all excused. Adair Regional Jail is scheduled for 10:30. Are you all ready up there?
Yes, sir. We're here, Judge.
Okay, we can go ahead and start if you'd like.
Timmy Alexander.
Do what?
Mr. Woods, he was reviewing his PSI.
Kenneth Woods, well, before we do this one, Adair came, we'll do Kenneth Woods. You have, he's got my PSI.
Yeah.
Your Honor, sorry about that.
It's okay. It's all right. It's okay. Everybody practices every course a little different. Just get acclimated, no problem. Commonwealth versus Kenneth Woods, 20 CR 0040. Mr. Woods, we previously identified you. And you need an opportunity to go over your pre-sentence investigation report with Mr. Kennedy. You had an opportunity to do that.
Yes,
Everything in there substantially correct.
yes.
Your diversion order, your diversion was, you originally diverted for a period of 5 years. It was voided on November 20th, 2025. Is there any reason this gentleman should not be sentenced?
No, Your Honor, we're ready to proceed. Judge, what brought us here today was Mr. Woods was on unsupervised diversion, or he'd been put on unsupervised by probation parole. He was set to expire in July of this year. He mistakenly tried to buy a firearm online, did not realize his diversion was still going and that was illegal. He has received a probated offer in Shelby County, which would have been entered last month, but for the snowstorm canceled court. He is in court in Shelby County on Monday afternoon and will be entering his plea on that case for a 2-year sentence that will be probated. I have conferenced this case with Mr. Stockton. I think there was an agreement to be placed on probation in this case, for whatever terms the court sees fit.
This is a 3-year possession case, I believe.
3 years, yes. There was a possession of cocaine residue case that he was on 3 years, diverted for 5 originally.
And he was probated up there. I don't mind if the court wants to probate him in this case, I'll have no objection. Based
What about the gun? What kind of gun?
Well, my understanding was he never had the gun in his possession. He tried to buy one and he failed his background check because he had a pretrial diversion pending. So he's gonna be probated on that.
Correct.
It's not like he had the gun, ever got the gun in his possession.
Only reason he didn't get the gun.
Because the system worked, I guess. Yeah. But I guess now he's gonna be another several years before he never have a firearm,
That's correct.
because he'll be on probation in this case.
Yes, Your Honor.
So you want to give him 3 years, probated for 5 here? Is that what you're gonna do?
All right, look at the reason why.
It was 3 years diverted for 5, I believe.
That's correct.
Yeah. So if the court wants to probate him, I have no
I'm not
objection.
crazy about probating,
But
but if you're agreeable to that.
I'm agreeable to it under the
Okay,
circumstances,
but
because,
here's the deal.
Yeah.
I'm gonna go ahead and sentence you to 3 years. I'm gonna probate it, supervise for 5 years.
Yes, Your Honor.
And then whatever they do up there to you're not. But don't you come back in front of me fooling with any guns. You understand that?
yes,
Because, you know, the combination of guns and drugs, I'd say maybe when you're sober, not under influence, you seem to be a pretty good fellow. But some of the dumbest things people do is when they're on drugs or alcohol and have a gun. So, you know, so you don't need to be having any guns. You're a convicted felon. You understand that? You meet with probation parole officer.
Thank you, Your Honor.
Yeah. Okay, there came Timothy Alexander. Commonwealth of Kentucky versus Timothy Alexander, 23 CR 0039. You are Timothy Alexander,
Yes, sir.
born in 1982. The last 4
Yes, sir.
digits, social security number 5227. You got a motion to revoke and a pretrial conference. What do we have on the pretrial conference?
first on the pretrial conference, Your Honor. In district court, Mr. Alexander was charged with burglary and strangulation. When the grand jury heard this case, he was indicted on burglary and assault for strangulation was not indicted on. And the witness appeared the victim in that case. Since we've had this case, I have met with the lady who owns the apartment that Mr. Alexander had I would say, altercation with or dispute with. He allegedly went in and grabbed her cell phone. And there was a dispute about whether she owed him some money or he owed her some money. I can't remember. But anyway, the lady told me that Mr. Alexander had permission to be in her apartment and that she never denied him permission to be in her apartment. So I don't think I can proceed with a burglary case. I've talked to the victim in the assault fourth that was defending the lady's honor, I guess, during the dispute. He doesn't want to prosecute the case. So what I'm telling Mr. Alexander's been in jail for quite some time. I've talked to Mr. Garner. Mr. Alexander had a pending positive meth case, positive meth test. So I'd say that might have led to the altercation if he was high on meth. So at this point in time, I'll probably ask the court to dismiss the burglary case and sanction him on the revocation. I know he needs to be set up with a DONTA on dual diagnosis treatment, and he needs some IOP treatment for his drug abuse. That's about all I can do.
What's the probation? What kind of
It's
probation?
a 10-year sentence, 5 years probate.
What was that for?
His previous assault. And that's what really bothers me on this case. Mr. Alexander, he'll go do good for a while, and it seems like he gets in an altercation with somebody again. And it's probably drug and.
How long has he been incarcerated?
Gosh, I'd say 3 or 4 months at least. He could probably tell you. Ever since this occurred, I guess. If you look at it.
You wanted to meet with
November at least.
Yeah, and one of these times, if Mr. Alexander doesn't change his weight, I'm gonna get something against him. He's gonna be revoked if somebody.
Well, it
goes
might be
back to court.
revoked this time. I
Right.
don't know what, you want him to meet with the professionals and see if he needs anger management or drug treatment, or what do you want?
Yes, he needs to get mental health treatment, drug treatment, and anger management treatment, any kind he can have. Otherwise, he's gonna be right back in front of it. This happened on November 13th of 2025. I believe that's how long he's been in jail. Since November of last year.
Okay, well, I have Mr. Alexander.
Sir.
I will tell you how this is going to end for you. Mr. Stockton said if he gets anything else, he's going to send you to jail. If people are afraid of you, somebody will kill you. It's not a person that's going to stand up and do a fair fight with you that you got to worry about. It's somebody that's afraid of you. I think with some of these histories, these confrontations, you might have some people that are afraid of you. I'm just giving you some unsolicited advice because I don't want you to get killed. Okay. I'm gonna go ahead and let you out. Continue and the days that you've been in are gonna be service sanctioned. They won't be good days. They'll be sanctioned days. And I want you to, when do you come to probation parole office?
Tomorrow morning, Your Honor.
Okay, I'm gonna let you out in the morning at
8 a.m.
8 a.m. You go to probation parole office in Columbia, meet with them, and they'll set you up with maybe some anger management or check on your drug use or something like that, okay?
Sure.
Don't disappoint me, okay?
I won't, sir.
You get out and get a job. You've always been very respectful. You know, get a job and maybe you can turn your life around, okay?
All right. Thank
Good
you.
luck. Jason Bowers.
Bowers.
Jason Bowers. Are you Jason Bowers?
Yes, sir.
Good morning. You're here on 22 CR 0082 for a shock probation revocation. You were born in 1984 and the last
Yes,
four
sir.
digits social security number 7956. Is that correct?
Yes, Your Honor.
Okay, you want to proceed with the shock probation revocation motion?
Yes, Your Honor, we'll put on, I'll probably have to call some officers. They may be in the grand jury.
Well, just give me a background of what you say has happened, see if we have a stipulation.
He's been on shock probation since May 23rd of 2024. On January 27th, 2026, officers here and locally were called to his residence. He was intoxicated with alcohol. January the 29th of 2026, officers were called. He was under the influence. They thought he might have been driving a car, but he wasn't caught driving a car, but he was under the influence that day. And then there was an EPO entered against him January 30th of 2026. Not knowing the nature of these EPOs, I don't know if that's been dismissed or if it's still in effect or what, because those things are kind of like sand through your fingers. But Mr. Sheffitt wants him to go to long-term treatment.
Yes, Judge, we've had him assessed. We've got a bed letter for him for March 5th. I guess it's next week. Next
What is
Thursday.
Tell me something about the EPO and BBO.
That's something I don't know. That'd have to be pulled up with the clerk, see if it's still that. Yeah.
I'd like to bring it up and let your staff or someone look at it.
Yeah.
To see what the.
Yeah.
What it's about.
Okay.
You got it there?
I do, and Officer Garner said he did complete a 60-day treatment. When was that through Art?
That was through August.
When was that?
That was August 24th.
Of
As
like,
soon as he got credit, he got a shot probation.
oh, okay, so it's been about 2 years ago. This looks like it was taken out by Catherine Humphrey. Says when Jason drinks, he gets mouthy and violent. He's been arrested for 2 violent charges and currently on shock probation. Jason has been doing well with drinking after he went to rehab when shock probation was granted, but then on December 23rd, 2025, he got drunk. And I have a video from the front door blank camera where he said he was going to stab me to death. And I had Paisley on my hip in the video. Fast forward to the most recent incidents, he called a suicide hotline January 27th, 2025. I was in Nashville doing treatment with my oldest daughter Lillian, who was diagnosed with a cancerous brain tumor. Jason, my sister, and Liam and Paisley was in the home. He told the hotline that he was going to kill himself, said he had guns in the home, which he does not. Cops was called to my house, Seth Stockton, another cop. Nothing happened. That was, I believe, on January 27th. On January 29th through midnight, Jason was drunk and had told my sister he needed to leave. And I told her on the phone that because I was still in Nashville, to not leave the house with him drunk without the children. He was driving our friend's car that he borrowed, Timothy Davis. I called Timmy. Brandon Poole and Lance Watson was out looking for him. He ended up coming back home. My brother had got there. He was gone. When he came back, he was trying to get my brother to fight him in the front yard. The cops came to my house after he got back, talked him down. My sister took my kids and left for the night. He was messaged me after and said, I wish the smoke alarms were still plugged in, but I couldn't catch it in time, and sent me 2 photos. I had a tote box with my kids' old drawing and school stuff in it, and the other, it wasn't in there anymore, insinuating that he had burnt my tote box with their memory stuff in it. I have yet to message and answer or any of his calls and texts. He has threatened to take Paisley, our youngest daughter, and go to Ohio. She's scared of him now. I have her now. Sometime during the night, last night, he had called my 2 oldest children's dad's wife and told her that he was going to kill Anthony, which is my oldest 2 kids. During which the phone call, Benny Bragg, my oldest 2 kids' stepmom, said he told her.
Okay, I get it.
Yeah. Kind of been on a rampage. This is according to Catherine Bobby Humphrey.
What do you have to
And
say?
he's on shock for wanting to, I believe, with the original charge.
You want a hearing on this?
Well, yeah, I mean, if the courts, if.
I'm gonna send it, if
Yeah, I
that's
need to get my
true,
witnesses.
he's
Yeah.
gone to the penitentiary. I don't take the people threatening to kill people or threatening to kill themselves or burn stuff. People always say, well, we didn't know he was gonna kill these people. Well, people don't say they're gonna kill or shoot somebody or burn somebody unless they have the inclination to do that. And so I'm not gonna be a party to that unless you can disprove. If they prove he said that, he's gone. So if you wanna have a hearing, you can stipulate.
No, I think we need to have a hearing,
I
Judge.
think you do too, because that was hearsay. Okay, we'll schedule.
Can I get my officer recognized and I'll.
Oh, you got officers here today?
Yes.
Well, let's have the hearing.
Well, I don't have Miss Humphrey here though, and those officers didn't write a report on
Okay,
either one of these.
officers, y'all turn your cameras on if you're there. Any of them here?
They're back to grand jury. We'll check.
Bring them out here, yeah, and we'll recognize them, be here on 24. Clerk says the domestic violence hearing is scheduled for the 18th.
I'll see that she's subpoenaed to be here.
Tanya, let's go on to the next case. I'll recognize them.
That's fine, Your Honor. I can do subpoenas again. It's no big deal.
Well, if they're here, you'll have to have them served. Could you check with Mr. Bay, see where they went, get those?
Because I got you. There's been anything for me, I'm saying that.
You're not there? Okay, we'll move on.
We'll move on.
Tanya Burton.
Switch back.
Your Honor, this is a case, she has a 5-year sentence on one in
Where
endangerment.
is she?
Oh, okay, there she is.
Are you Tanya Burton?
Yes, sir.
You born in 1975?
Yes, sir.
Last 4 digits of social security number 5085.
Yes, sir.
You're on 21 CR 00133 at pretrial diversion revocation. What's the Commonwealth have to say?
Okay, it's pretrial diversion case. She's a 5-year sentence, Your Honor. She's had multiple violations, failed drug tests, sent to rehab. My understanding, she's gonna stipulate.
That's correct, Judge.
We'll stipulate order of pre-sentence investigation, revoke pretrial diversion. Order of pre-sentence investigation report to be done by probation, parole, and have sentencing on the 24th. Okay. Albert Davis.
Let's see.
Albert Davis.
Mindy, I got if you're ready. Burton, go ahead.
Are you Albert Davis?
Yes, sir.
Good morning. We're on
Good morning.
24 CR 0063. Were you born in 1971, sir?
Yes, sir.
Last 4 digits of your social security number 8453.
Yes, sir.
We're on a probation revocation. What's Commonwealth have to say?
Albert Davis.
Your Honor, this is a motion to revoke probation. He's got a 3-year sentence on possession. He's had some positive tests. I'd ask that he be assessed for drug court if the court agrees.
Mr. Davis, do you have a job anywhere you work?
Yes, sir.
Where you work?
I've been working for Milltown Construction.
Okay, well, what we're gonna do is the Commonwealth says they're willing to give you a shot at drug court, so you won't go up. Would you be willing to participate in drug court program where you can be free and work and that sort of thing?
Yes, sir.
Okay, well, I'll go ahead and do a referral for that. They'll do an assessment on it. It takes some months, some weeks to process it and get you back from the thing, but gives you some hope that you can get on that and get out, okay?
Okay, thank you.
Okay. Okay, thank you very much.
Judge, I have an order to present. I think Commonwealth gave it to me. Do you have one? Sorry, that's okay.
Olivia Kendrick. Lorraine. Are you Olivia Kendrick?
Yes, sir.
Good morning.
Good
We're here on 26 CR 003. Miss Kendrick, were you born in 1997?
Yes, sir.
Last 4 digits, social security 1886.
Yes, sir.
Okay, you're represented by the Office of Public Advocacy previously in district court, is that right? Did you go to
Yes.
district court?
Yes.
Did you have a public defender in district court? Did a lawyer stand up there with you? Was there a human being in a suit or something standing there next to you in district court?
Yes, sir, but
You
I'm
don't
from
remember?
Marion.
Well, you're from Barron, but you're charged in Cumberland, that's right.
Yeah. Yes, sir.
I'm gonna appoint the public advocate and have her do an affidavit. Okay, ma'am, you born in 1997,
Yes, sir.
last 4 digits, social security number 1886, correct?
Yes, sir.
Okay, I'm gonna read your indictment here and give it to your attorney. The grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance, first degree methamphetamine, possession of drug preference, possession of synthetic drugs, possession of marijuana, driving on a suspended driver's license, failure to maintain insurance, reckless driving, and speeding. Counselor, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea not guilty,
Yes, Your Honor.
reserving all pretrial motions. I'm going to enter, the standard discovery order so that Commonwealth will share with your attorney information to help prepare your defense. Negotiation day in this case is on the 13th. Next court date's on the 24th. What's the bond in this situation? Do what? Wonder why that would have been.
She was thinking of Brand County operating. No, other maintain current insurance and such.
Was she out on probation or anything when she was arrested?
She got arrested on those days. She got picked up from Marion County and he revoked her bond.
Okay. Okay. Did you hear that? So she got picked up on a different charge in Barron County. I revoked her bond. So we'll address the issue of bond when we have the negotiation day. Negotiation day 13th, next court date 24th. You'll need to do a transportation order. Okay, Judge. Austin New. Harlow versus Austin New. Are you Austin New?
Yes, Judge.
You're here on 24 CR 0032. You were born in 1986. The last four digits, social security number 8510.
Yes, sir.
Okay.
Morning, Your Honor.
We have a
Sean
motion
Farr.
here. We have some motions. Mr. Farr, you have a motion to vacate. Say what that is?
The Commonwealth filed two motions. One to take video testimony of the of Deputy Lindsay because he'll be out of the country. I have no objection to that, Judge.
Yeah, we'll have, if there's no objection, then we'll have to get some dates and schedule that when you're available.
Let's do it today.
Well, I can't, he's in Indiana. He's the investigator that began this case when the young lady disclosed where she resides. But I'll skip
When's
some
the
dates.
trial set for?
It's set in June.
Okay, well, then 30 days from today, let's set the video deposition.
Okay, I'll get with Mr. Farr.
Farr, you'll be in contact. But what's the motion about?
The other motions vacate. In this case, Your Honor, typically any general public can attend the court. Also, the proceedings are streamed on YouTube. In this case, there will be at least over 10 videos that are graphic in detail that is explained in the motion that the victim will have to authenticate. And during the victim's testimony and during the playing of those videos, I'm asking that there be no streaming of YouTube and that the personnel be limited in the courtroom. And you know, even under the open records request, these materials are not, they're considered child sexual abuse. Not discoverable. They'll be closed sometime once these proceedings is over, and they shouldn't be disseminated to the general public.
You don't have any objection to that, do you, Mr. Farr?
Judge, it's limited or just seeking clarification. Of course, I have no objection to YouTube. I didn't know that it was even happening. I have no objection to that. I have no objection to the general public being barred. You know, we do have a general principle that courtrooms are open and public, but I'm looking, of course, to have the defendant present, and then I didn't know whether the court would consider permitting my client's immediate family to be present. Perhaps not. I don't know whether the videos themselves, but during any like testimony around, you know, kind of other circumstances.
I'm not following what you're saying.
I'm
You
not
also,
difficult hearing.
you need to look into the camera and speak into the microphone a little bit.
Judge, I would like my client's family to be present during
What family are you talking about?
his wife and his aunt and his sister.
They have no business, they're not parties to this. They have no business seeing this stuff that's double X rated.
Well,
So
and
the courtroom will be open. And if you have any tendency to, or intention to call them as witnesses at any phase, and that they'll be excluded by the separation rule anyway.
I understand, Your Honor. It would more be, they might be privy to just overall circumstances and might be able to kind of, essentially advise, Judge, sometimes.
They're not gonna see it. No, I'm not gonna nobody in the public's gonna see it. Your defendant and you will be there. And even in the courtroom here, we're gonna clear the courtroom except for necessary on those particular things, on any videos or anything that might be depicting the defendant or any other minor child will not be made public, and we're gonna try to find a way to seal them, even if they're part of the record, subject to be open on appeal if there is a conviction. Okay, what else? Is there anything else you have, Mr. Shaw?
No, just those two motions.
Okay, Counselor, while you're here, do you have anything else?
No, Your Honor, we'll get together and get the deposition scheduled and conducted, and we're on track for the June date.
Okay, thank you very much.
Thank you, Your Honor.
Next is Jimmy Otterson. Commonwealth versus Jimmy Otterson, 19 CR 0067 and 26 CR 008. Are you Jimmy Otterson?
Yes, sir.
Were you born in 1991?
Yes, sir.
Last four digits, social security number 9087.
Yes.
You're here for an arraignment today. You have the right to remain silent. The Office of Public Attorney is here. The grand jury of Cumberland County has returned an indictment charging you with assault in the second degree and being a persistent felony offender. Mr. Bailiff. Counselor, do you acknowledge the identity of Mr. Otterson? Receive indictment, waive formal reading and arraignment, and plead not guilty, reserving all pre-trial motions.
Yes, Your Honor.
There's a motion for shock probation revocation, which I sure will be held in abeyance. This other issue is addressed. Negotiation day shall be on March the 13th, and the next pre-trial will be on the 24th.
Judge, I would like to address bond. What is the bond on the new indictment?
$10,000, yes.
Would the court be willing to allow?
He's charged with, he's out on bond on a case that involves violence, correct?
That's correct. He's on probation. And then
Probation.
And then he got discharged for
And he
violence.
gets charged with another charge involving a physical altercation or hitting someone. So we'll have to have a hearing if you want a bond reduction. You can set a hearing if you want one.
Well, I'm actually not asking for a bond reduction as such. I'm asking if the court would allow the $10,000 bond in the new CR case to stand also and release him on the PV case, like the 19 CR 67.
I would not be agreeable at this time. I spoke with the victim this morning, and the victim's not enthused about sending Mr. Otterson to prison for a long time on this. But evidently, Mr. Otterson's made statements when he gets out, he's not finished, and that does concern me.
Well,
I don't think he
we're
can
just
come in
gonna
from the
have,
background
we're just
either.
gonna have to have a hearing on this, okay? Now, what's the bond?
Your Honor, I've not made no such statements.
Wait, don't say anything. What is the, on which one of? On what? The new case?
If we need to have a hearing, we'll have a hearing. I don't know. All I can go is by what I'm told.
$10,000 cash.
And people staring me down in the courtroom, certainly not gonna help Mr. Otterson in this case. I'm not gonna be
Were they
intimidated.
here?
Saying,
They
listen
leave?
to what you're saying.
Okay, well, all this buckets and everything going on.
My daughter was.
Hey, be
crying
quiet.
for that.
You be quiet. You be quiet, okay? Thank you. Well, I'll leave the bond the same as it is. It would appear to me that we'll just, the fact that he was out on a pretrial diversion or probation on the same case bothers me, okay? So we'll have to have a hearing on it. Okay, William Taylor. William Taylor. Commonwealth versus William, are you William Taylor?
Yes, sir.
You're on 25 CR 0084. Were you born in 1995?
Yes, sir.
Last four digits, social security number 3136. We're here on a pretrial conference. What do you have to say?
Your Honor, this is Greta Atherton. Again, I was there earlier for April Nethery and,
You want to turn your camera, you want to turn your camera on? So
yes,
you
I'm
can
sorry.
hear? It's
Yes, sir.
okay.
Mr. Nethery, Mr. Taylor was added to my contract as well. And I don't have the discovery on him at all yet. So I would ask the court if we could set him also on that negotiation day of the March 13th.
Okay, negotiation day on March 13th, next court date on March 24th, okay?
Thank you.
Yes. Rebecca Thompson. Are you Rebecca Thompson?
Yes, sir.
Good morning.
Good morning.
25 CR 0074. Ms. Thompson, were you born in 1980?
Yes, sir.
The last four digits of social security number 9406.
Yes, sir.
We're on a probation revocation. What does the Commonwealth have to say?
Ms. Thompson has a 2-year sentence on possession of controlled substance, first degree. She absconded and had 2 positive tests. My understanding is she's gonna stipulate.
Okay, is that correct?
That's,
Okay, she stipulates we will revoke probation. Okay, thank you very much, Ms. Thompson.
You're welcome.
So, I hope things turn around for you.
All
Carol
right, thanks.
Walker. Carol Walker.
No.
Stand by the door till Minnie's there.
25 CR 0085. Are you Carol Walker?
Yes, sir.
Born in 1965.
Yes, sir.
The last four digits of social security are 9875.
Yes, sir.
You're here on a pretrial conference and a motion to revoke bond. Yeah, was she out on another charge when this was?
She'd been charged with burglary, and while she was out on bond, she committed another burglary that
Allegedly.
she confessed to. So that's being presented to the grand jury today.
Well, let's just continue this thing to the next negotiation date. Have a remain in jail till then. March the 13th is negotiation day, and the next real day is March 24th. And hopefully the indictment will be returned by then. They can either serve her or issue a summons. We'll take a look. If she's gonna be in jail, we might just do a summons.
She had a copy on most of these, no go to release that back.
Who signed it?
Or-
Yeah, I'll release the bond. She's in custody. Okay, Richard Whitlow. Commonwealth versus Richard Whitlow.
Email ready to go.
25 CR 0079. Are you Richard Whitlow?
Yes, sir.
Good morning.
Good morning.
You're here on, were you born in 1975?
Yes, sir.
Last four digits, social security number is 0884.
Yes, sir.
It's a pre-trial conference. What do we have?
I think we're still negotiating. I don't know.
if Judge, I just got we've been going back and forth a little bit, and I've seen Richard a few times, and I've got a new offer, and if we could set it for the 13th, I'd like to have a chance to go see
Negotiation
him.
day. 13th, the next court date's on the 24th. Your attorney will be up to see you with a new offer, Mr. Whitlow.
Your Honor, can I ask you about bond? I've got
Well, let me
medical,
find out, what is this bond? What's the charge?
It's a trafficking case, yeah, problem.
What do you have?
More likely, it may be a boat trial, maybe a possession. I don't know, I'm just telling you, 3 or 4 grams of meth, I think.
Certainly, Judge, from the defense perspective, we believe it's a possession case.
Well, they said that, well, I said the bond that high for some reason.
Well, it's charged with a trafficking, so
That wouldn't only be the reason.
He's got prior convictions. Probably.
Did you PFO him?
Yes, he's got a PFO.
That's the reason he was probably set aside. You what? What has he got in Marion County? Was that pending? That's the reason he had a pending felony bond out and then was charged for this reason. So we can have a bond hearing on him. Once we find out more information about it, I will consider it. I just don't know enough now. Thank you. Raven Willis. Raven Willis. Are you Raven
Male.
Willis?
Yes, sir.
Good morning. We're here on 21 CR 0061. Miss Willis, were you born in 1991?
Yes, sir.
Last 4 digits social security number 8224.
Yes, sir.
On a shock probation revocation. What does the Commonwealth have to say?
She has a 3-year
Get up to
sentence.
the microphone.
She got a 3-year sentence on possession. She received a DUI. After she was arrested on the DUI, Officer Garner went and tested her. She was positive for meth and marijuana, besides her prescription medication, which was benzodiazepines and Suboxone. So I'm asking that she be revoked.
Judge, we would stipulate for purposes of today.
Okay, we'll stipulate. And revoke the probation. Okay, thank you very much. Nicholas Ray. Nicholas
Female,
Ray,
right? Yes.
42 CR 00016. Are you Nicholas Ray?
Yes, sir.
Morning. You're on
Morning.
CR 0016. Mr. Ray, you born in 1999.
Yes, sir.
Last 4 digits, social security number 1919.
Yes, sir.
You're on a pre-trial diversion revocation. What does the Commonwealth have to say?
Your Honor, Mr. Ray has a 3-year sentence, possession of controlled substance, 1st degree. He graduated from drug court. He was out. He got a new DUI. Officer Garner went and tested him. He used marijuana and meth prior to the DUI, and I'm asking for revocation.
Judge, we would stipulate today.
Stipulate, revoke the pretrial diversion, set up a pre-sentence investigation report, probation, parole, and have sentencing on March the 24th. And does that include, your attorney will be up to see Mr. Ray, okay? Does that conclude the criminal docket? Adair County, do y'all have anybody else that thinks they're supposed to see me today?
That's it, Judge. That's everybody.
Okay, well, we will release you and thank you for cooperation in Adair County.
You bet.
We
Have a
are
good
in
day, Judge.
recess. No, I have what kind of docket do I have? Clinton County motion here. Commonwealth of Kentucky versus Christopher Braswell.
There you go. I will give.
Mr. Braswell here.
He's not, Your Honor. I didn't tell him. I just filed this yesterday. It's a motion limiting.
I think he's got a right to be here.
Yes, sir. It was,
Where is he?
I'm sure he's out on bond. I'm sure he's at work.
So off the record, please. Or zoom off on something. Okay, now we have several motions that were just filed. When's this trial scheduled for?
Next Wednesday, Your Honor.
This is Clinton Circuit Court indictment number 25 CR 0088. And what dates is scheduled?
Next Wednesday, I believe it is the third.
We're a little short notice on these motions.
Especially since we
We
have
haven't
not
seen
seen them.
Well, they ought to go very easily then.
You might have.
We filed electronically yesterday, so I thought you would have.
We don't get the electronic notice on it.
Oh,
Yeah.
I'm sorry.
It
Yeah.
might have been Jesse's email, that's probably connected to the case.
Okay.
I'm anxious to see a motion in limine that Mr. Hunley would be in favor of, but unless he filed it.
And Your Honor, we need to reschedule this to be heard on Monday.
Reschedule it. Let's take a look at schedule. This is serious
Okay.
charge, and
Yes,
we
sir.
have read the motion because we got it. Staff lawyer's seen it for a few minutes. Okay, the trial is scheduled for Wednesday. I'm gonna be here on Monday. We have that Clinton County Hospital case that been settled.
No, that's the damages hearing where it was.
Yeah. It hadn't been settled. It was on the third, right?
Like one on appeal, so I got it.
So it's gonna be on the third.
Yeah, Tuesday.
See, I'm gonna be, what I was saying, I'm gonna be, this is the Clinton County case. I'm gonna be over there on Tuesday. But the trial scheduled for Wednesday.
This is a case involving sexual abuse charge.
Get behind the microphone there.
It's a case involving a sexual abuse charge of a 26-year-old man and a 13-year-old victim. I think under the rape shield law, it's set forth in rules of evidence 412. Depending on what's in his motion, he would be required to give us 14 days notice. Of course, we haven't received any. And I don't know what the basis of the motion is at all.
Well, I'll tell you what, let's do. Let's go ahead and let you review the motion of Commonwealth. There might be things you're in agreement.
That's possible.
Possible. So let's look at that and see if y'all can negotiate any of the things. And then I'll make a ruling on whether any of the others are timely filed then, okay?
Okay, and just for the court, this has nothing to do with the rape shield law.
I'm not saying it did.
Okay.
Okay, Mr. Hunley said that. It's his position. I haven't assumed a position yet.
Yes,
Well, since that's what the case is about, I assumed it might have something to do with it.
We abound with assumptions today, but
It's
if
just.
y'all, while you're all are still here, maybe the Commonwealth can look at this for a few short minutes, sit down and go over it, or maybe go back in the room and go over it together, and it might be an agreement. I'll accept an agreed order.
Yes, sir.
And I'm not inclined, this trial has been scheduled for a long time, and I'm not inclined to continue it. But if there's anything to be heard for the record, we can get on Tuesday. I'm gonna be over there on Tuesday for here, what time's the hearing scheduled? 9 o'clock. So somewhere after 11 o'clock, I would think I'll be available if y'all need to hear me have it heard on Tuesday in Clinton County. Okay, thank you very much. Does that conclude? Do we have a show cause, Doc?
Yes. It's been about an hour.
I didn't really. That's really
Stop directly. We can talk to you.
He ended up going to Clinton County, they got crashed.
Okay, we'll call the show cause docket. I don't see the show cause docket. Where is the show cause docket? That's a mistake. Okay, Commonwealth of Kentucky versus Jimmy Clark, 25 CR 0063.
Judge Peterson, court notice, and he's actually called, but there's not been taken.
Okay, issue a bench warrant, he purged himself by paying $100 out of $190. So Commonwealth versus Stacy Harold.
She's called also, she's been making payments. She makes $30 payments, but that's not been payments.
Issue a bench warrant, let her pay $70. That's what she owes. Commonwealth versus Kenneth William.
Judge, he's been paying also, got not heard from him this month.
Issue a bench warrant, had to pay $145. Commonwealth versus Maggie Scott.
He's called also, and was supposed to call back and make a payment, and has not. She's supposed to pay $50 a month, and that's it.
Issue a bench warrant, let her purge herself by paying 100 of the 285. Okay, that concludes the show cause. We are in recess until 1 o'clock. Thank you. Everybody have a seat, please. Call it child support docket. Barngover versus Marion.
Judge, this is the Commonwealth's motion for contempt.
These folks are coming up here behind you.
These are the respondents.
Okay.
Judge, as of today, the Mr. Barngrover is $2,114 in arrear. He's ordered to pay $302 a month, asking that the court issue a contempt order for him and allow him to purge himself of that by paying $1,000 on or before March 23rd.
Okay. Look, electronically file the order, we'll sign.
I will.
Ray versus Cowan.
Judge, this was the Commonwealth's motion for contempt. The respondent came in yesterday and paid the full balance, so there is no longer an arrearage. That would be it.
Remove it from the docket. Was that one that's all arrearages and no current payment?
Yes, they're current now in both respects.
Okay. Hey, it's taken care of. Thank you. Okay. Parrish versus Shawnee. Just Shaw hand rather.
Yes, Judge, I'm here for Ms. Shawhan virtually.
Okay, wait a second here. You need to speak up a little bit. Okay, what do you got?
Judge, this was another of the Commonwealth's motions for contempt. We received proof yesterday that her tax refund was garnished in the amount of $3,763, and she paid yesterday her February payments. She is current now too. So I ask that be removed from the docket.
Okay, any objection to that?
No, Judge.
Okay, thank you very much. That concludes.
Thank you.
That's all I have, Judge.
We're a little early on the civil docket. I'll call the first case to see if the parties are here and are ready. West Bend Mutual Insurance versus Fletcher Excavation.
Judge Mike Van Sickle for the defendant West Bend, appearing via Zoom.
It's a motion for summary judgment. I've read your brief here. What kind of, Mr. Wilkerson, what kind of response do you have?
Judge, we were able to file actually a response today. We were asking for, looking at rule, CR 5603, which is the notice requirement, for a summary judgment motion.
You need to speak up a little bit.
So, Judge, they filed their summary judgment motion on, February the 16th. It was late in the afternoon. We've not had an opportunity to fully prepare and get this.
Let me ask you something.
Yes,
I've
Judge.
knocked this case around for quite a while. What is their defense? They've been given an opportunity to provide proof that this was wrong, this was wrongfully paid and that they made payments on it, but up to this point, according to the brief of the plaintiffs, they haven't shown where it was wrongfully paid. And then, do they have any proof that it's wrongfully paid, or are we just kind of knocking this thing around?
I don't believe so, Judge. And the reason being is on two different fronts. You know, looking at this, you know, prior to, I mean, this is an action on a surety bond, right? And so there's
Indemnification, right?
That's right.
Yeah.
Indemnification. And I believe the facts come down in two different buckets. And one of the buckets is how did the claim get settled? The underlying claim that was made by a supplier against the surety, right? And how was that claim settled? And we believe that.
Okay, well, let's stop it right there. The underlying claim, okay, so this job was bonded.
That's correct.
Okay, and then the underlying claim is because your clients did not pay for materials. And so plaintiffs went against the bonding company who had bonded payments on these things, received payments, but have never, you're saying it was unfair practice or something in settlement, but you never have shown any proof that your clients paid for this material and therefore the payment by the bonding company was improper. And I think that, I mean, I've read and reread this thing, and I think that's the crux of the matter. Now, and all these other, some of these other defenses you made under fair practice, I don't think apply to a commercial situation like this. I think the plaintiff is correct on that. I'm just asking you plain out, does your client have any proof which has not been provided to the plaintiff that they paid this and therefore the settlement which they seek indemnification for should not have been made? It's a simple question.
Well, the reason why it's not as simple is because.
It's a simple question for me that I want to answer.
There was, okay, so, but again, we have to look at this in two different buckets,
Well,
Judge.
this is the bucket I want to look into it. And
Right.
if you got an argument that will change whether they're responsible for it, I just want to know if your clients have any proof that they made the payments and the payment by the bonding company was improper and against their interest and that they shouldn't be able to be indemnified.
The amount, Judge. So if we're talking about tip to toe, right, if it was like, there's absolutely no obligation to the supplier at the original outset of this, right? If we're saying that there is the obligation was totally wiped clean by my clients before the bond company paid.
Had they paid it?
Have they paid it?
Did your clients previously pay?
Prior, no, but the dispute is with regard to the amount, right? The dispute is with regard to the
Well, we
amount.
need proof as to the amount. You know, the proof is to the amount. If your clients paid half of it, then the bonding company should have just paid for half of it and you'd be allowed an offset against this indemnification judgment. That's what I've got to know. Do you have any proof where your clients paid for any of this material that was supplied?
Well, in the course of discovery, we requested a myriad of documents to which West Bend has provided most, I don't know if all, but most. And inside that, there were invoices from the underlying supplier for the original claimant.
What proof do you have by your clients that they paid any of these bills? I don't think it's that incumbent upon the bond company that the bond company paid a claim for unpaid materials that your client they say did not pay. I don't know whether your client paid it or not, but I've seen no proof. All this time we've been jargling this case around. You've had an opportunity to come in and bring proof that your client paid this and that the bond company inappropriately paid that bond off. And I haven't seen any of it. And when I ask you straight up, you don't give me any numbers.
Okay, well, so yes, there were offsets. And so the claim wasn't about money actually having been paid. We believe that there were checks that were actually paid. The underlying claim is by Consolidated Pipe. Yes.
Is that your client?
Them or the person, the principal who would have been issuing the checks on the job, right? They would have diverted payments to Consolidated Pipe, which is the underlying claimant against the bond, the supplier of pipe. This is an excavation company. They were saddled with big jobs. Barron County Board of Education, did some stuff for Western Kentucky University.
Where's the proof that your client paid for these materials or someone paid for these materials on their behalf? Where is that proof?
We believe that there is at least some amount.
Well, what amount? See, this has been going on, this discovery has been going on and back and forth. You have to give them some discovery too. And we could end this case and get around all this stuff. If your client, are you saying your clients don't know how much they paid?
To be candid, no, we do not.
That's a problem.
That is a distinct problem. And we've been earnestly trying to get to that. A lot of it also hinges on the amount of offsets. This Consolidated Pipe, the original claimant against West Bend's bond, they had a lot of different projects going on at various different times and also in conjunction with one another. I mean, they would have been, there was like a job in couple of jobs in Bowling Green, Glasgow, but But again, Judge, that's not the crux of this. And what I'm saying is there were offsets. There would have been returned materials. And that, we don't believe that there was adequate offsets
Well, then
provided.
you need to provide proof of that.
And we believe with the invoices that have been provided through the discovery that we requested, we've been able to at least make a showing of that. I'm asking today.
I haven't seen it yet.
Judge, and that's the thing. They filed this 10 days, less than 10 days ago. And so under the rules, and I've cited the case in our response, I understandably, it's a hurried response, but so is the motion itself. I mean, the rules clearly state that it needs to be more than 10 days. And so
And Judge-
also with regard to that, outside.
Let's the attorney for the plaintiff speak here. Go ahead.
Judge, we've got no objection to allowing him at least 10 days, passing this for a hearing on another date and allowing him time to file an actual response to our motion.
Okay.
Well, that sounds.
Okay, you file one within 10 days from today.
A response.
A response, and in that response, I want you to outline the payments or offsets you feel like your client is entitled to. Is that unreasonable? This case was filed.
But that's not the only issues at play here, Judge.
Okay, what's the other issue?
The other issues at play, and again, I hate to harken back to these two buckets, but it really is, right? After the bond was, the bond issued supposedly a payment to West Bend, which is also somewhat of a factual dispute. We've asked for the check that was actually written, a copy of the check that was written to the.
Okay, let's stop it. Do you have a copy of the transfer of funds or checks?
Judge, I requested that from West Bend, and they were able to send me like a screenshot today showing where essentially, I think a screenshot of their bank account maybe showing that it cleared, and I think they requested it from their bank, but the bank doesn't have a copy of it to give to them, probably because it's been 8 years. I don't know, but either way, they said that they don't have an actual copy of the check, but they did send me essentially a screenshot of their account showing that with the check number and the amount paid to Consolidated, and then
have that out.
Check.
What else do you need?
It's within their internal ledger. And we also would never received any sort of release or proof that the underlying claim was ever released or there was a lien release. But again, that's just maybe a segue into the second bucket, which is the parties may very well went into a brand new deal. This installment agreement that the Fletchers were then making payments to West Bend, admittedly so. We believe that there's, I would like some more time to prove to the court, not only the first set of circumstances and facts that you're trying to get at, as far as, are they owed any sort of offset? Did they make any sort of payments that would have eroded that claim that they're making? And the second one is, once the Fletcher started making payments, was that a novation? Did that create a brand new contract with brand new terms? Because part of this, Judge, is that they're asking for attorney's fees and interest owing pre and post judgment interest, but and a lot of that is derived from the original indemnity agreement. And so after this claim was paid to Consolidated Pipe, supposedly, again, we've not seen the actual check that was written or a release that Consolidated Pipe granted to the surety company or my clients. But then afterwards, once there was an agreement that was sent out and said, hey, we're here and we're going to try to collect on this payment that we've made to one of your suppliers. What can you do? And then they start making partial payments and actually send them.
Did that happen?
It did.
Well, have you got proof of that?
Yes, we did.
I haven't seen.
And again, Judge, if we'd had adequate time to
You're going
bolster
to get
this.
adequate time, but look, you've had years. There have been years. How long have you been involved in this case?
I got into it last year, Judge.
Last year is the operative word. So I want
That's right, Judge.
I want some action done. I'm tired of fooling with this case. Your clients need to put up or shut up, okay? And I want some proof on what you say on payments that they made or payments. I mean, you surely don't think that someone's going to try to come back on them and collect for this material that they allegedly didn't furnish. It's been paid off. And now the bonding company paid it off and they want their money back. Okay, now if you can show where your clients paid any of that debt before the bonding company do, I'll give you an offset for it. Okay, if you can prove that they made payments after that to the bonding company? You say they made payments to the bonding company? Is that who
Yes.
they made payment? If they do, then we'll address that issue. But at this juncture, the motion for summary judgment is up and you haven't given me anything to go your way on at this juncture, and you got 10 days to do it. Okay, thank you very much.
And Judge, may we have 7 days to reply?
How many?
7 days after?
Yeah, you have 7 days to reply. Thank you very much, everybody.
Thank you, Judge.
That's all I have.
Yeah, absolutely. Have a safe journey. Shootman versus Housing Authority of Burkesville.
Yes, sir, Your Honor. Matt Cook for the Defendant Housing Authority.
Yeah. Yeah. Mr. Cross is here. Mr. Cross, you have filed a response to motion for summary judgment today?
Yesterday.
I got it today, so.
Sorry, it was filed as the rules require yesterday.
Okay.
I received it yesterday afternoon, Your Honor.
Okay, now what do y'all have to say about this? This is tar paper coming through the crack of the ramp case. Is that right?
That's exactly right. And I've cited in my motion.
Wait, you're gonna have to speak louder. Turn it up somewhat.
All right. Can you hear me now?
Yes.
All right. Yes, sir. This is a case, and I've cited in my motion, the law that.
Wait just a second. It doesn't help him coming up here. Get him some of these earphones. We're gonna have to get some earphones from Mr. Cross.
Judge, I apologize for not
Wait
being
just a second.
there.
Wait just a second. Wait just a second. We're gonna get some earphones.
Okay.
Say something now.
Yes, sir. Can you hear me okay?
Okay, go ahead.
All right. And first of all, let me apologize for not being there. I just got over
That's
surgery.
okay.
So
Move on. Move on.
all right. Yes, sir. All right. I've cited in my motion that a landlord is not liable for injuries caused by defects in leased premises unless the condition is unknown to the tenant and not discoverable through reasonable inspection. In her deposition, the plaintiff here told us she was aware of this material sticking up from the ramp, never reported it to her landlord, never asked for a repair, and therefore we feel like summary judgment is warranted based on the fact that she admits she was on notice and took no action to request any sort of repair.
What do you say, Mr. Cross?
Your Honor, I appreciate Mr. Cook's motion and I understand defense counsel.
You're gonna have to speak up too.
Okay, I'm sorry. I'll do my best. I can hear myself really well. If you take everything that he says is correct, which it's not necessarily correct in this case, two problems. Number one, the slope is not according to standard, and we filed photographs. I was real surprised when I got out to Oakland Heights and I looked at Ms. Shootman's ramp. It's steeper than the ones across the road. And we have to get into discovery and do that. And number two is the rail broke. The rail's never been fixed, by the way. It's been repaired, but it's never been replaced.
The rail broke during this fall?
Yeah. Yes. See, she fell and tried to catch herself on the railing and it broke. So I understand Mr. Cook's argument, but it fails, and we'll get into it. I've sent him some, I've got to depose his maintenance guy and whoever move forward.
May I respond?
Sure.
I'll just point out this case has been pending for over 2 years, and prior to yesterday, I never had any request to produce anybody for a deposition. I think Ms. Shootman, the plaintiff's deposition, is dispositive on this issue under the landlord-tenant law, and I don't see how any other discovery is going to change what she's already testified to.
Your Honor, I'm going to ask their maintenance guy why there's the slope. I've made my point. I understand.
The ramp wasn't up to code is what you're
Yes,
saying, and the rail wasn't up to code,
fault.
and it gave way is what you're saying.
Correct. Enough said.
And I read the deposition. She was going down with a cane as to whether she was left-handed or right-handed and that sort of thing. So, but I will tell you that it's a little difficult for me to continue to have these cases that have been languishing around for 2 years and no discoveries, and then happen or anything happens till a motion for summary judgment happens and then they get going. So I'm going to give you some days to take discovery.
Thank you.
Now, I will think that his motion, on the set of facts that he has present, that he makes a pretty good argument about that, but the slope and the improper building of the rail could change that, but very close to a summary judgment. Now, how many days do you need to finish your depositions and things? 30 days?
No. March is a bad month. What about, I'd request 90.
No, I'm not gonna do that.
I guess I'll take whatever you say.
45, okay?
All right.
You have all your discovery finished in 45 days, and we'll come back here. I guess you'll have to wait, counsel, to see if he does any discovery that touches anything, and then you might ask for some additional time when you do that. If not, we'll schedule it for May the 28th. How about May the 28th?
Now, point of clarification, Your Honor, do you want, regard to my expert, do you want their report tendered in the file prior to then, or?
Well, you're going to depose your expert, aren't you?
Well, it's going to, no, I wanted them to depose my expert. I'll bring
Well,
them.
who
to
is
trial.
your expert?
That's to be identified.
So you don't have an expert.
After we take their
So you
deposition.
don't have an expert, and you don't really know what happened on the rail or the ramp, but
I've
you're
been out
hoping
there.
something did.
I've been out there, Mr. Cook has
I
not been.
understand.
Yeah.
I understand what you've got, and you've got, my favorite term is a stew that was made out of a shadow of a crow that starved to death. That's what you got up to this point, but you're hoping it'll fizzle out. So, okay, you got 45 days to complete your discovery, and you need to notify him within, let's say, 30 days on who your expert
Fair
is.
enough.
Okay, 30 days. And counsel, if you'll draw the motion, counsel of plaintiff, draw my order up and submit it. 30 days to give him the name of your expert and a report, and 45 days, which the 30 is inside of that, to finish your discovery. Okay?
Now, are you overruling his motion at this time?
I'm holding it in abeyance.
Let's just overrule it.
Well, the thing about, we're not making the ruling. I'm making the ruling, and I'm not overruling.
Thank you, Judge.
Okay, okay, thank you. Connor versus Honeycutt.
Honeycutt's here on Zoom from Grayson County.
Can you turn your camera on? There you are. Okay, I got you. This is 24 CI 0038. It's a motion for surname change. Ms. Capps is representing the plaintiff or the petitioner. And Mr. Honeycutt is incarcerated now, and therefore he's entitled to counsel by Ms. Wanda White. Is that right, Ms. White?
That's correct.
Now, I've read Ms. White's, can you hear it all right, Mr. Honeycutt? You hear
Yes, sir.
okay?
Yes, Your Honor.
Everybody that's not on this motion, could you turn your cameras off if you're not being heard on this motion? It's a little confusing as far as the record. If you're not involved in this motion here in Connor versus Honeycutt, turn your camera off. Whose camera is up at the top? Yeah. Mr. Smith, turn your camera off. You're not on this motion here, I don't think, okay?
Okay.
Okay, thank you. Okay, I've read Miss White's response to this.
And Judge,
Yeah,
in response to her, written response to her motion, she cites a case that was in effect prior to the legislature making the change to the statutory requirements. In July of 24, in KRS 401.020, there's a statute that came into place that changes what that case said. So basically, that statute says that if one parent refuses, then the court has to consider all relevant factors to change the name of the child, which includes the wishes of the child, as well as the interaction and relationship.
what do you say about that, Scott?
Well, the first argument that I make is there was an
Well,
order.
I don't want to talk about your first argument. I want to talk about your response to what she was saying.
My response to that is the Lockheed's case was cited. I know of a case in 2019 it was cited.
For
But
this,
even-
for this proposition here, or for
Yes.
something else?
Yes, the Likens case said there must be significant detriment to the child before the name is changed. What she's stating is more elements should be considered as such, the child's wishes. This child is 7 years old, and I think that alone would establish that, there should be more significant contact with the father. He is due to get out in, I think, this summer.
This
Is this
March,
copy of
next,
the statute that you're in up here?
That's the copy of the
Do
statute,
you have a
Judge.
copy of the statute?
I don't.
Make a copy of that for us, please. So
Yes,
we
but
can
you
look at
care
the
to
same
make
piece of
two
paper.
Judge, the last time
Wait
we.
just a second.
Okay.
I'd like to deal with one issue at a time, okay? Did you address this issue in any response?
I have not yet,
I
no.
didn't think so. I thought I'd read everything. Always be helpful. Give her a copy. You got a copy, Ms. Gabbs?
I think Mr. Abernathy has my copies.
Okay. Okay,
And I apologize, I don't have a copy that's not marked up. I just want to make
that's
sure everyone
okay.
can see that.
It helps us get down to thing. Now, Ms. White, she says that A, B, C, D, and E are the criteria that shall consider all relevant factors, including, so it would be your position that these are not exclusive factors, that this says that all factors, including those, and you think that there's case law that would add another factor. Is that
That the
correct?
child would be.
Is that correct?
Yes.
Okay, thank you. Now, what's the?
Judge, it was my understanding that her argument was that because neither of the parents was agreeing to it, that was the only basis for the court to consider. And she keeps citing case law from 2001, 2019, and that's what I'm saying. This statute went into effect after those cases.
Okay, but if this says the court shall consider all relevant factors.
Yes, and that's what our argument
Wait,
is.
including these, which means there could be other relevant factors. And what she's saying that case law is still good because it states other factors that should be included and were not excluded by the legislature. That's what she's saying. Now, that doesn't mean you can't get a judgment on the thing because of that, but she's saying that she thinks that factor should be considered by the court. And I don't think that you can argue that maybe it shouldn't be unless you have a case that it says it can't be. So we've got over that hump. Now, what's the harm done? This child is raised here, and at some juncture, if things continue down the road, and I'm just going to be perfectly frank, if things continue down the road that we've been, the next thing at some juncture will be termination of parental rights. Okay. Would you agree with that?
That could be a possibility if
Could
he
be a
does not.
possibility. And then you cite the agreement that they made not to have the child's name, but some significant things have happened since that agreement. For example, your client is in jail for continued activity. That's a material alteration of the situation that existed at the time this agreement was signed. You agree with that?
I think
You agree with that or not? Or you want to take issue?
I'm not sure he wasn't in jail at the time or
No, I don't-
already sentenced.
You wouldn't know. Well, I'm
Is he-
not aware that he was in jail at the time. I don't believe he was. I think this is subsequent to that. So other than that, other than you think that if I consider these issues, the wishes of the child's parents, which obviously these people, the petitioners are and have equal status of a parent because of the ruling this court did. That they are. I mean, you agree with that?
I do, but
Okay, now let's go to say the wishes of the child, due consideration, blah, blah, blah. Well, the child is little and the pleading said the child was asking questions why he doesn't have the same last name as a sibling. Well, the interaction, interrelationship of the child with his or her parent or parents or siblings or any other person may significantly affect the child's best interest. Well, these people are raising the child. The father is in jail. So motivation, adults participating in the proceeding. This child is without assets. He doesn't have any assets. So the only motivation that they could be would be positive the mental and physical health of all individuals involved. Now, there hadn't been any challenge that these folks don't have any obvious or mental or physical problems have been diagnosed or reported to the court. So the main argument that you have against this name change, and they're not eliminating your client's name, they're just adding a name to it, doing a double name. What would be the main argument that that shouldn't be done?
My client is strongly opposed to that.
I
He
know, but
feels
what
that
is his argument about it?
His argument, of course, was our number one argument, that there was an agreement entered, and his consideration of that was that the child's name would not be changed. That was part of the consideration that he entered into. Secondly, he has joint custody. He gets out of jail maybe in 4 months at the most, and he hopes to reestablish a connection with the child.
And we'll hear that when he wants to. Nobody said anything at this juncture yet about him not reestablishing a relationship with the child. I haven't heard them say that yet. I anticipate it'll come at some juncture. So that's not an issue. Okay, what's the other issue?
At the most, Your Honor, we would request that this be postponed for maybe 4 months when he's out, where he can make all of his motions together for whatever other recourse he wishes to have. I know this order states that he has the child every weekend, I believe, and sometimes it laps over to an extra day if there's no school.
The original, when he gets out of jail, you mean?
Well, the original order was
When he
that.
gets out of jail, he can
Yes.
start.
Your Honor,
So-
I'm supposed to be released an MRS in March.
Judge, I've got his Kentucky online offender. I don't know where he's coming up with the information he gets out of March. His earliest parole eligibility date is September the 1st of 26. And then if he gets out with good time credit, he's not going to be served out till November of this year or until March of next year.
Well, that's not really before me right now because
No, but I'm just saying-
nobody's trying to limit his visitation at this juncture. Do you have anything else?
I mean, I could just ask him a question of
You
why.
want to put him on?
I
Go
would
ahead.
like
Will you raise
to.
your right hand, please? You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes.
Okay, you may inquire.
Mr. Honeycutt, you've heard the arguments and you're aware of the statements that I've made that you relayed to me. Would you tell the court why you feel that it's not in the child's best interest to have his name changed as asked?
I'm unsure if it's Jackson's suggestion or if it's coming from the Connors. I just don't know if there's manipulation there. I've been incarcerated for the last 12 months. And I will make mandatory release in March. It's on my timesheet. It is mandatory. So I don't know why we can't postpone it. I'm just hoping for a continuance. If you could give me 60 days to get out and maybe hire my own counsel that ain't covered by the Connors.
It's not what?
Covered by the Connors.
What do you mean by covered by the Connors? I don't know what you mean by that.
Are they not billing or paying the bill for my attorney?
No.
Judge, my clients had to pay when she was appointed in the district court action.
Well, that was a court order. It doesn't mean that she has any obligation, quite the contrary. She has an ethical obligation to represent your interest. And by the way, has done quite a bit of work on these documents that have been filed on your behalf. And I doubt very seriously whether you can hire anybody that would do a better job than this brief or make more ardent arguments. So that kind of falls flat with me, but go ahead.
That's all I had, Your Honor.
You don't have any other questions you want to ask her?
Could you restate what you said when you think you're going to be released and why you think it's earlier than what Ms. Capps said?
Yeah, when you're sentenced to 3 years or longer, you can make mandatory release within 8 months of your sentence date. So my sentence date is November the 20th of 26. 8 months before that makes it March. So I should be released in March.
Have you confirmed that with the staff at the facility?
It goes through probation and parole. My family has contacted Frankfurt multiple times, and it is in March. I got a DOC timesheet that says my MRS eligibility, and it's 3/22/26.
That's all.
That's a mandatory release.
Judge, I would like to ask Mr. Honeycutt, Mr. Honeycutt, isn't it true that the only way this child's name was actually changed from Hale in 2024, I guess in September of 2024, was through the help of the Connors, correct?
That's true.
So your child didn't even actually, you didn't take any proactive steps to even give your child Honeycutt as a legal name, did you?
I needed a birth certificate with my name on it, and I got it after I was incarcerated.
But again, you did not take any proactive steps yourself to make sure that this child's last name was changed to Honeycutt, did you?
I did the first step, which was to get a birth certificate with my name on it so I could actually do that.
And in the year that you've been incarcerated, it's correct that you've actually not spoken to Jackson on the phone, isn't it?
That's not true. I've spoke with him when he's at my family's house.
Well, then you've not tried to make any contact with him while he's with the Connors, have you?
I've not spoken with the Connors.
And prior to you being incarcerated, your order said that you got every other weekend with your child as long as it was at your parents' residence, correct?
That's correct.
Okay. And your parents have not had consistent every other weekend visitation in the year that you've been incarcerated either, have they?
That's not by their choice. That's because the Connors won't allow it.
I mean, the Connors have allowed your
Every
child to go visit with
once or
parents,
twice a
correct?
month.
Ask a question.
I just did, Judge.
I didn't, he entered, put the question, is it true that so-and-so, whatever? You start out like a statement. He's interfering with the answer if you don't tell him it's a question.
Isn't
That's
it,
the question he has to be.
isn't it correct, Mr. Honeycutt, that during the year you've been incarcerated, your parents have actually got to exercise visitation with your child?
That is true. Not every other weekend.
And so as we sit here today, you can't say that Jackson does not want Connor added to his last name, can you?
I can't say that he does either.
But you've not had any contact with Jackson.
It's not a compelling argument what a child of this age wants his last name. Okay. Anything else to ask me? Well, when I look at the statute and I consider the things, I'll need to make some findings of facts and conclusions of law based upon the best interest of the child. So I'll have to do that. But de facto custodians under sub A, in my opinion, are on equal status to the child's parents or parent, if I understand de facto custodian. We have testimony that the child has expressed interest in being named. I think that's true, probably, but it's not compelling. The interaction and relationship with his parents, there had been very little, if any, interaction between the respondent and the child because of his continued propensity to get in trouble and be incarcerated. Motivation of adults participating in the proceeding. Now, I'm not a family court judge, but I've dealt with this case for a long time, and I've never seen any motivation of, of Mr. Connor or his wife, the biological mother, or his wife rather. And biological mother is not involved in this anymore, but I've never seen anything that Mr. Connor or Miss Connor have done that don't indicate that they have any ill motivation. The child does not have assets they wish to garner or anything. And the mental and physical health of all the individuals involved. From previous testimony, it appears to me that the child is well adjusted and doing well in school and is accepted in this nuclear family. So I'll make these findings and I'm going to order the name change. And when I get it out, it'll be final and appealable. So you don't worry about filing an appeal on it yet, okay?
I was going to ask if I could be relieved from
Well, no,
representation.
you can't. It'd be too easy. Because if you got relieved, I'm going to at least let you wait and protect his interests as far as a notice of appeal. And if he's gonna get out when he says he's getting out, he doesn't want you to represent him anymore. And I think you've done a commendable job
Thank
on
you.
this case. I don't, but if he doesn't want you to represent him, that will give him time to get his own attorney to appeal this thing and see if I'm wrong. Okay, now you can submit, both of you can submit some proposed findings of fact, conclusion of law in this case. Okay, well, thank y'all very much. for
Your Honor,
the-
just to protect his interest, I think I would raise the fact that there's been no testimony put forward to base the decision on.
I've had plenty of testimony in this case for a long time.
I wasn't aware, I wasn't involved until recently.
Yeah, well, the petition is self-evident that one of the parents wishes the name to be changed. It's not necessary to put testimony about that or they wouldn't have filed it. They said that the child wants it, the child can't be covered. We can put him on and let him go down through these allegations, but this is a verified complaint. Isn't that correct?
It's a verified complaint and also a verified, he signed off on an affidavit.
It's an affidavit, so that I'll make sure that the affidavit and the verified complaint to answer your question. Now, you have any questions you want to ask him? Just to give you a right
No,
across.
I just had to state that objection.
Well, I know and to cure that objection, I'm gonna give you an opportunity to ask him any questions if you'd like. You'll raise your right hand. You swear the testimony about to give us the truth, whole truth, nothing but the truth.
Yes, sir.
Your Honor, I thought it's their burden to put on their proof.
Why?
Okay, well, we can call him and let him go down through his affidavit if you want to.
Okay.
You want to do
I'm
that?
just, the appeal issue was mentioned, and I just have to raise these.
Okay, well. Yeah, well, I'm gonna say that the affidavit and the petition are sufficient. And that there was no cross-examination of him when the opportunity was given as to the validity of those, that'll cover it, okay? If I'm wrong, full appeals coming. Thank you very much.
Thank you.
Let's go to the next case here. Tax Break Kentucky LLC versus Larry Murray and others.
Judge Eric Craig here for Tax Break Kentucky LLC.
You turn your camera on,
Getting it. There we go.
okay? Is there anyone here representing Larry Murray and others? Pardon? I said, yeah, but there are others. Yeah, that's their still named party, yeah.
They just call them response, well, they give it to their state.
Yeah. They filed a response. I think that the motion that you filed that says that evidently the land passed through intestacy.
That's correct, Judge. Pursuant to KRS. Go ahead, I'm sorry.
I'm familiar with it. Mr. Murray is deceased. I knew him, fine fella. And he had this tax lien on him, I guess, on the property, and he's deceased and you want to commence it. Now, one thing that wasn't addressed very much, there wasn't an estate started. I guess somebody stated there wasn't an estate started, but you're acting against the land.
That's correct, Judge. That's correct. And no matter, as far as we can tell, I'll put it that way, we can't find a probate case in the Commonwealth of Kentucky.
Well, of course,
that much I can say.
you could start a probate case as a creditor, couldn't you?
I suppose I could,
Well,
but it's
I
not
know
necessary
I know you-
because, I'm sorry, Judge, go ahead.
Because when they're, so if you'd like to come to district court, start a probate case and pass this from me would be fine. But I think that you got a right to enforce your lien. So I'm gonna give you a judgment on the thing. And have you paid your $300?
Yes.
How much is it to refer to Mass Commission?
Judge, this is not the motion for judgment order of sale yet. This is just a motion to amend the complaint to bring in the two errors that we found.
I thought you'd already served them. You hadn't served them yet?
I think we sent a copy along with the motion to amend.
Okay,
So
well,
they have a copy. We still need to serve the
order to
complaint.
amend, and then we'll put it off another month and you get a judgment then. Make sure you
Thank
send
you.
$200 in, okay?
It's 206 through the electronic e-filing system.
Okay, thank you very much. Have a pleasant day.
Thanks, Judge.
Okay. Another satisfying question. Let's see. Where's my docket sheet? Okay. Powell versus Cooper. Okay. Okay, what do we have here?
Your Honor, it's my motion to dismiss on this. Ms. Powell filed a motion to be deemed de facto custodian and,
You allege that they were out there jointly with the custodian and that time doesn't count.
yes, Your Honor.
Yeah, what do you have to say about that?
Your Honor, when they lived there, Miss Powell provided the home, paid the bills, provided a lot of the food and supervision, and was a primary caretaker of the child, which is her children, which is what's required under KRS 403.270. I don't think there's anything cited to that says just because the children were in custody of somebody else that she's
Well,
precluded from filing.
that is the question here, isn't it, really? If you have a custodian living there with a significant other or somebody else, are you able to establish the sort of contribution that a de facto custodian has to make? And I quite frankly haven't dealt with this situation. I don't do that much family law. I don't know. Do you know the answer to that really definitively with case law?
Your Honor, the only thing I've have found close to being on point is that two people could be found de facto at the same time. So it's not necessarily just one caretaker. But I do believe that we could put on proof that shows her level of involvement to help the court make his determination of this.
Now, what are the relations? I got a little confused as I read the motion.
Me too.
As far as who's on first, who's related to who and everything. Kind of do me a short diagram of you got two children involved, right?
Yes, Your Honor.
Okay. We won't call their name because we're broadcasting. Okay, so you got two children. Who are the biological parents of the two children?
Courtney Willis and David Powell.
Okay. Now, are they involved?
Mr. Powell is deceased.
Yeah,
and
Mr.
Courtney
Powell
is
is,
not.
I know Mr. Powell now that you say he's deceased. Okay, and Courtney Willis. Now, and your client is Delcy Powell, correct?
Yes, Judge.
And what's her relationship with the children?
My client's Miss Cooper, Your Honor.
I'm sorry. Yeah, my client's Delcy Powell.
She's the grandmother.
Yes, she's grandmother of one, and then as her son would have been I should say step grandmother of the other, resided in her home.
Your client, what's the relationship?
She is the maternal grandmother of Courtney Willis.
Of one of them?
Yes, Your Honor.
And is it the same one that your client is, or is it the other child?
I'm a little bit confused. My client is the paternal grandmother of one, and then the step paternal grandmother of the other.
Okay, and she's the maternal grandmother
Yes,
of
Your
one of them, but not the other.
No, she's maternal grandmother of both of
To
them.
both of them?
Yes.
Okay, I got you. And the children have, now where does Courtney live now?
Mount Vernon, Your Honor.
So she doesn't have anything to do with the children?
No, Your Honor.
And how long's it been since she had anything?
I think you got custody in 24 or 25 weeks.
I got custody as one of them.
She actually.
How long have they been living with you? I'm not asking, the custody's a different situation.
Well, one's been almost over a year. The other one has been over 3.
Okay, so we would have a situation on whether or not she's a de facto custodian or not, unless she's a grandmother. Do grandparents have to establish custodial?
Your Honor, I believe that's correct. She, I know, did get some custody earlier this year. But I think I'm really confused, but I think she resided with them too.
She did.
Yeah, so.
But she's gone.
But she's gone now with the children.
Yeah, she, ever since the child was born, or actually September of 22, she's lived in the same household with
Courtney has.
grandma. Yes,
Courtney
Miss Cooper.
has. Yeah, but your daughter is Courtney, right?
Yes.
Okay.
Yeah.
Now, where are the children now?
They're with me.
They're with me. And so Courtney's gone.
She's in, yeah, she lives in.
I don't care where she is. She's gone.
Yes.
How long's it been since she's lived with?
She's been gone about 3 years.
Okay, now what do your clients want to accomplish? I know they want de facto status, but ultimately, if they get de facto status, what can you tell this lady that what kind of involvement? The other side is the grandparent to.
Your
one of
Honor,
the children.
she would just like some type of visitation with these children.
Okay, well, that might be able to be accomplished if y'all sit down and talk to each other. So in other words, if you reach an agreement as far with a grandmother and a step grandmother about visitation, it looks like that fate has given you all the responsibility of raising these children, as many grandparents have now. I know you have a lot of friends and associates that have grandparents raising children, right? It's an unnatural thing, but in our society now it happens quite frequently. So what you need to do is go out and let the two lawyers talk to see if you can agree somewhat to let this other grandparent have some visitation. She's not trying to take the children away from you. Is that correct?
That's correct, Judge.
So that way we won't have to get into any proof about what kind of home you've got, or they're not challenging what you're raising the children right, or any of that sort of thing. It would appear to me that a good agreement on this would be better than putting at risk who ends up with the children, because I don't like the Solomon bit where I have to be threatened to cut the baby into. You know what I mean? That only worked once, and a lot of times in my court, they go ahead and cut the baby into. So y'all step out and talk about that, and we'll address this thing, okay? Jones versus Jones. Jones versus Jones. They withdraw that motion. Where is Holly? Holly Perigin? Perigin, are you on Jones versus Jones? Who is?
Jones versus Jones.
Johns versus Johns. I was calling it wrong. I said Jones. Johns versus John.
Judge, that one will be continued. I was contacted by the opposing counsel.
Okay, you want to continue it?
Yes.
Fine with me. I will tell you that I'm a little concerned about where all these assets are and how I've got jurisdiction, all of them, just as you get ready for it, okay? I don't want to talk about it any more than that. Morales versus Pruitt. Motion withdrawn, okay? Teachers Federal Credit versus Don Lid.
Good afternoon, Your Honor. Veronica Stewart, on behalf of the plaintiff, it's our motion for judgment and order of sale.
Okay. Is anybody appearing here for Don Ledford? Okay. Okay, well, if you'll electronically submit a proposed judgment, I see it's here. We'll go ahead and enter the judgment.
Thank you,
Okay?
Your Honor.
Thank you very much. You have a blessed day.
You as well.
Everett Lake Holdings versus Opal Edwards.
Your Honor, Christopher Combs for Everett Lake Holdings on behalf of Katie Lawrence.
You wanted to leave to file an amended complaint?
Your Honor, we
Is
made a
there
motion.
any objection to that? Pardon?
Yes, that's correct, Your Honor.
Okay, if there's no objection, submit an electronic order and we'll enter it, okay?
I believe there's one filed with you.
Card, okay, we'll enter it then. Clerk verifies it's been filed. Car tax lien portfolio versus Warren Northey, Karen Northey Warren, really.
Your Honor, Christopher Combs again for car tax lien portfolios.
This is the one where there's a military stay. Do you have an objection to the military stay?
Your Honor, don't believe we are allowed to object to that.
Well,
I would ask I'd ask the court to give us some time to work out a payment plan, hold this in abeyance until we can do that. I know Mr. Poindexter had asked Ms. Lawrence about some of the particulars of what's owed. Some of that's attorney-client privilege. However, we would like to talk to them some more about getting a payment plan in place. I'm just hoping.
Okay, let me pass this out. until, when is your client expected to be discharged?
She's career,
Well, I know, but you know, I got a term of office too, but it ends. You know.
I don't know, Judge.
Some people today wish it went in sooner than later, but
If you want to give us till May or June, Your Honor.
May the 28th. Redocket this for May the 28th, and I would encourage, there's nothing in the federal statute that keeps you from negotiating on terms or
Correct.
anything, correct? So if you'll contact Mr. Poindexter, be assured that he will negotiate with you. Okay, thank you
Yes,
very
sir.
much.
Thank you, Your Honor.
Thank you, Judge. You have a great day.
Now, is there anything else on the docket?
Just what you sent out the page.
Yeah, this is the pal, we'll wait for the pals to come back in. Now, we have a deep EPO or DP. Okay, we're gonna call the 7702 docket. And then these are cases to be dismissed for lack of prosecution that we're required to do under Rule 7702. Roy Anderson Lumber Company versus Medical Care Center of Bowling Green. Yes. Okay, you need to stand down here so they can help me on this. Okay. Okay.
There was a case that was on the docket. I just didn't know what had happened to it.
What it was, did I skip over it?
First, Franklin Financial versus Maddox.
What happened to it?
Oh,
Okay, sorry.
thank you.
No problem. Roy Anderson Lumber Company versus Medical Care Center of Bowling Green, is that right?
It is on the same docket back in 2022 and nothing's been filed and I've not heard from any.
Okay, it's ordered to be dismissed. National Collegiate Loan versus Timothy Spears, 14 CI 0033.
It's on the past two NDLB dockets.
Do what?
It's on the past two NDLB dockets. There's no service on Timothy Spears.
Okay, ordered to be dismissed without prejudice, I guess. Mullins versus Rich.
It's on the last docket. Nothing's been filed.
Ordered to be dismissed. Ballard versus Oversheimer.
I think it's on the last NDLB docket.
Ordered to be dismissed. It's a 2019 case, I guess. Gary Wade Willis versus Joanne Willis.
This case is started from a number of, there was never an order for recommendations.
There was what?
There's never been an order to adopt the recommendations.
Okay, well, what I want to do is send, this notice has been sent out. I want to send a letter to Ms. Capps. Mr. Cross, your counsel on this case.
Your Honor, Ms. Capps, whatever. She and I don't know if these people want a divorce or they don't. We're trying to find out. I thought they did, and she said they did.
Mr. Willis called the office, yes, he's still on divorce.
That's what I needed to know.
Okay, well, were you the petitioner or you represent, you were the attorney for the petitioner?
Yeah, we had an agreement and quite frankly, and she was going to draw it, draft the agreement. She
Why don't you see if you can get her on the phone?
was just here.
She's right there.
There she is.
Yeah, grab her there. Well, don't grab her, but ask her to come back in here.
Not to get
It's
approached.
rude.
I asked Mr. Willis to call his house. I did.
Ms. Capps, we got the, calling a dismissal docket, 7702, in the case of Gary Wade Willis versus Joanne Willis, and the clerk has informed us that these folks want to be divorced, and it was heard in front of former Commissioner Sohn. So what will be necessary? Did y'all have an agreement, Mr.
We have an agreement.
Okay, well, if you submit me an agreed order,
I had previously sent it to Mr.
I don't
Cross.
care. I want somebody to send it to me.
Can do it.
I'll sign it. Okay, so let's keep that on the docket with parties, attorneys being present, so they'll take care of it. Okay, Casey Anderson versus Sarah Hayes. Casey Anderson versus Sarah Hayes.
It was on the docket last time also, we can do, and then we've been filed.
Okay, dismiss it. Family Tradition LLC versus John McKinney.
In November 22, there was an order entered to submit trial briefs and none of them filed since.
No objection.
Dismiss it. Mr. Hurt must have been representing the defendant.
All mine. Yeah, I looked at them all mine.
Okay. Cliff Carley versus Shannon Whitaker.
There was a cross claim.
No objection, Your Honor.
What was it now?
There was a cross claim filed in 21, but that's the last thing that's been filed.
Mr. Poindexter was involved in that case, but you were attorney for the plaintiff, correct?
Yes.
Okay, we'll dismiss it. Ford versus Ford, 21
Both parties have reconciled.
reconciled, dismiss it. Cumberland Valley Manor versus the estate of Bernard Smith.
There was a response filed in 22, and nothing's been done since.
Mr. Hurt, you're attorney for,
Those are my, they can go to hospital. But I don't represent them anymore. It's been sold, so it's all been done.
okay. Dismiss the case. The same for Jeanette Diamond, dismiss the case. Larry Murray, dismiss the case. Medical Center Bowling Green versus Bobby Riddle.
There was an answer filed in 22, and that's the last thing that's been filed.
He's deceased now. Is that the same Bobby Riddle? This is Sean. Hodge and Adams were the plaintiffs. You were the defendant. Have
I
you?
represent the defendant in both of those, so I certainly have no objection. He's on payment, but I don't have any objection to him being dismissed.
Okay. So on payment plan, we'll dismiss it. Gross versus Alexander.
No objection. It's there.
I don't agree with that.
You're attorney for the plaintiff. You have no objection.
Okay.
Midland Credit versus Vanessa Case. No service. We'll just, I'm gonna leave it on the dock. And you need to, contact, you just send a notice that the case was called, there's been no service, they need to take some action or it will be dismissed in 30 days, okay? Capshaw versus Commonwealth.
Your Honor, this is Joel Smith. I've got a motion to withdraw due to a medical issue. And also I would like to give my plaintiff, Andrew Capshaw, at least 30 days to obtain substitute counsel.
Your Honor, Evan Jones for the Department of
Get
Parks.
behind the red microphone.
Yes, Evan Jones, Department of Parks. We have no objection to the 30 days or Mr.
Okay,
Smith's.
we have submit an order, Mr. Yeah, we got an order withdrawal. I'll sign that and give him 30 days to have a counsel to enter an appearance, so the case will be dismissed.
So I wouldn't have, would it be redacted if you had a problem?
No,
Should I file a motion?
there's nothing been done on it. Have you taken any discovery or anything on it, or?
Couple depositions. It's been over a year, Judge.
Yeah, well, file a motion for summary judgment, I guess, at some juncture. I'm gonna let him have counsel, let the person get up to speed, and then once they get counsel, you can call and talk to the counsel. That's kind of falling out of fashion these days for lawyers to talk to each other, but. you can do
We
that.
talk.
Okay, thank you very much.
Yes, sir.
Thank you.
Carol Davis versus Christopher Fisher. Pardon?
No, nothing's been filed since we did earlier response, we take that that's all.
Mr. Wilkerson was here earlier in the day. What kind of case is this?
I think Mr. Fisher had built up on him, there were some issues.
Okay, we'll go ahead and dismiss it, and if they want to set this aside, they can. Aaron Beaver versus Clifford Riddle.
Your Honor, Ms. King asked if that be left off, and I've agreed, but I would just state on the record, if she doesn't get something going, I'll want to try to stimulate the thing a bit, but I have no problem with staying on it.
Okay, keep it on the docket. Attorney for the defendant and plaintiff had reached an agreement to put a short fuse on. Darby Gross versus Stephen Gross. Reconciled. Mr. Cross, that was your case there. Larry Anderson and others versus Donald Anderson. Yeah.
One of the ones has passed away and the respondents actually moved in with the other something.
Who are the attorneys involved? There weren't any attorneys involved? I'll dismiss the case. These Andersons here go by nicknames or something. What Andersons were they? Okay. Discover Bank versus Francisco.
There's not any service in that case.
Okay, you just lay it out there and send a letter to the attorney, so there's no service and they need to obtain service. It'll be dismissed on the next motion call. Okay. 30 days. David Powell versus Margaret Powell. Cease. Dismiss that case. Okay. Okay, it's 2:00 for the DVO docket.
Your Honor, if you call Williams and Strong, I know Dr. Henry's on and I'm here.
Did I call what?
Huey Williams versus Danny Strong.
I don't see it on the docket.
Megan asked to be taken off because there was
Speak up.
Megan asked to be taken off. There's interrogatory stuff.
Interrogatory's been filed. It came off the docket.
Did you get that?
I did get that. I'm gonna
Well,
send
let
you
me
some as well, David. Thank you, Honor.
Okay, thank y'all.
Good to see you.
Yeah, take it easily. Pritzker versus Pritzker. 25D 0016.
She wasn't here.
I'm here, Your Honor.
Can you turn your camera on, please?
I'm having a hard time getting it on here.
What, have we heard anything from? Okay, there you go. Teresa Pritzker. You see where she went? She was in the courtroom earlier. We'll come back to this case. Flanagan versus Flanagan.
I'm not sure where they are, Your Honor. It will walk out. Mrs. Perigin's representing me, Mr. Cross is representing my wife.
Somebody knock on the, just have the bailiffs to knock on the doors back there and see them.
Ma'am, I'm Flanagan, it will be Perigin and Cross.
I think Mr. Cross forgot the case and left. Did he leave?
Judge, Mr. Cross is the other attorney on this case, and I think we at least have a temporary resolution for right now.
Who's the other attorney?
Mr. David Cross.
Is he here?
I think he was, there he is.
Flanagan versus Flanagan.
We had everything taken care of.
I told him we've got at least everything temporarily wrapped up.
At least we're doing a mutual restraining order and trying to work on some.
So you dismiss the,
We don't dismiss the DVO until we get the other thing entered.
Then agreed mutual restraining order. We'll be drafting one, sending one to.
so you're gonna pass over this DVO thing and waive the time limit, correct?
Yes, Judge.
Okay, that'll be fine. Good.
Thank you.
Dishrun versus Dishrun.
That was also numbered.
Do what?
That is fine. 1 second, let me grab her.
Where's Mr. Poindexter? Is he still here? Is Mr. Poindexter still back there somewhere? Dishron versus Dishron? Okay, we got Dishron versus Dishron 26D002-001. You John David Dishron. And you are Jessica Dawn Dishron. What do we have here?
Well, it's my understanding there was an EPO that was filed in district court prior to Ms. Dishroon filing the petition.
And it came up to me.
It's come up. We've now filed a response on behalf of Mr. Dishroon's behalf. And we've had some discussions, so I don't know if she wants to continue with the EPO or if she wants to do a civil restraining order. I'm not.
Judge, it is our position that she wants to move forward with the EPO DVO at this time.
Hey, do I have this file here?
Yes.
Okay. Okay. Let me hear this, and it's, after hearing this, there might be some resolution without continuing the testimony. Y'all can weigh that. You want to call your witness?
Judge, I call Miss Jessica Dawn Dishroon.
Okay, you're gonna have to speak up louder, please. You gonna take a stand up here? Raise your right hand, please. You swear the testimony about to give some truth, whole truth, and nothing but the truth.
Sir.
Take a seat, lean toward the red microphone, use your outside voice. As prepared as you're going to have to speak up to.
Yes, Judge. Can you please state your name for the record, please?
Jessica Dawn Dishroon.
Okay. And what is your relationship to the defendant?
He's my husband.
How long were you guys married?
20 years.
When did you separate?
He left December 30th
Okay.
of last year.
Okay. Do you guys have any children together?
Yes, ma'am.
What are their ages?
8 and 14.
Who have the children primarily resided with? Who has been the primary caretaker of the children?
I have.
Okay.
Judge, I would ask that she put a time frame on that. Are we talking about since?
For the entirety of their lives, who's been their primary caretaker?
Me.
Okay.
Me.
Okay. Can you tell the court what led to the events of you filing the petition for protection on January the 13th?
After he walked out, of course, there was conversations about what was to happen.
Were you threatened in any way?
Yes.
How were you threatened?
He told me that I would get what's coming to me, that hellfire would rain down on me, and that,
It's okay.
that I knew what his capabilities were.
Is he currently upset with the judicial system?
Yes.
Okay, Judge, I'm gonna object. That calls for speculation.
Judge, I've got proof and it's relevant to the case. Has Mr. Dishroon had any conversations with you about how unhappy he is with the judicial system?
Yes.
Why is he currently unhappy?
There was a lawsuit and we pretty much lost the case. And so he was not happy with how the case turned out.
Okay, Jessica, I have a text message that you presented to me. I would like to
Well,
show.
before you get into this, let's get to the relevance of this thing.
Okay,
Right now, we're here on threats he might have made.
so you
toward
have
her.
been threatened by Mr. Dishron.
Yes,
Do you feel that he is going to follow through on those threats?
yes,
Does he currently own a firearm or gun, weapon, anything of that nature?
yes,
Has he ever used those items in front of you?
yes,
Have you ever been threatened with those items?
yes,
Do you believe that he is a mentally stable or sound individual?
no,
Have you ever witnessed Mr. Dishroon having a hallucination, memory lapse, or loss of memory?
yes,
Okay. Have you ever experienced any outburst from Mr. Dishroon which result in mental or physical abuse?
yes.
Well, she needs to expand upon that.
Please expand
In
upon
your
that.
affidavit here, in your complaint, you talked about him hitting holes in the wall with his fist.
Yes.
Firing a gun. Have her just about some facts, not what her conclusions are.
He has gotten angry and hit the walls. There's a big hole in our bathroom wall. He has hit his truck multiple times. He's broke his hand.
Is he hitting with his hands or with
Yes.
objects?
His hands.
Okay.
He has threw an iPad out in the yard and shot the iPad. He has
Did he shoot the iPad with a gun?
Yes,
Okay.
with a
and
pistol.
Was that in front of you?
Yes.
Was that in front of the children?
No, but they heard it from inside and
The
they
children-
come outside.
The children were inside and
Yes.
heard the gunshot
Yes.
and came
Judge, I'm
outside.
gonna object
Yes.
to Ms. Perigin testifying if she wants to ask her
I
questions.
agree. You're leading too much.
And
Sustained.
then I was outside on the porch. He came out on the porch and he sat down beside me. He pulled a pistol out and while looking at me, fired 2 shots. One was about that far from the four-wheeler that was
I'm
standing in
sorry, can you
front.
show that to the court about approximate that distance?
It was
please?
about that far from the four-wheeler that was sitting in the front, right in front of the porch. Our son heard Dad and came out onto the porch and saw where he had shot. There has been a lot of mental and emotional abuse for me and my children. My daughter is on different medications. She has a psychiatrist now. She has a therapist now.
Okay, and is
Again,
this,
I think we're getting outside the rail because we don't know what other things are going on in the home.
okay?
We're just kind of all over the map here.
In the petition, he has screamed, cussed at our children several times in his anger. He would grab a belt and go towards our children and I would have to get in between them. Can you tell the court about that?
Is that true?
Yes, several times.
Have you had to physically intervene between Mr. Dishroon and your children?
Yes,
Was he physically coming at them with a belt?
yes,
Did you feel it was very unnecessary?
yes,
You felt the need to protect your children?
always.
Okay. Does Mr. Dishroon regularly carry a firearm with him?
Yes, he never travels without one.
Okay. Currently, is Mr. Dishroon, under any type of medication?
He's on a bunch of different prescribed medication.
Are some of those medications narcotics?
A bunch of them are, yes.
Okay. Have you ever witnessed Mr. Dishroon take, quote, extra medication?
Yes, and he has told me several times that today's the day I need extra. Today I've got to take extra. I'm a little loopy because I've took extra.
Let's wait a second. Are we streaming here? Take this down. We are, because he's getting into private.
Make it. There.
Okay.
She'll have them here.